Can know one and two. I mean, the recommendation was it. I had a method fixed in protocol one also. And my senior officers come up, so can it take another group of.
Let me hear Mr. Chaudhary first. Let me hear Mr. Chaudhary. If need be, I will hear you.
Then what's it about? Can I do my part? Local person. Local, I do my part. Senior can do that.
I think you mentioned item number 14, my lord. It has become infrastructure.
Item number
14.
Yeah, your name?
Yeah.
Mr. K. Uddin, the learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous. Taking into account the above submission, the writ petition stands closed. Interim order, if any, stands vacated.
So I did mention item number 8, doctor, we are newly engaged in this matter.
Yes.
Not prepared, doctor.
Who is not prepared?
So we are actually not prepared.
Hmm?
We are actually not prepared, doctor.
Who are you?
Just got engaged, just
Who are you? Minister, you are appearing for whom? Have you informed the other side?
What should we try?
Inform them, then we'll see. Yes, Mr. Sharma, this is the matter pertaining to the handcuff.
Yes.
You see, I would like to have a look at the case diary. I'll put it up. When can you get it? I'll put it up for to be spoken to. No. That is why. It's a CAV matter. You remember that handcuffing of the lawyer?
Yes.
Where I have done the CAV. I reserved the judgment. But while they dictating the matter, I think they will have a look at the case diary as to whether there has been any recording as to why that person had to be handcuffed. No, not today. I will have it on Thursday. Today is Thursday, no? Tuesday. Thursday? We'll put it as to be spoken to.
That by invoking section 42, my lord, this issued assessment permit. Again, there we preferred an appeal. Appeal was allowed. Again, the appeal matter, division of preferred by being state. And in division, my lord, regarding 2-3 items, relief was given to us. And regarding packaged drinking water, my lord, it was not. So being agreed, my lord, we approached the lordship. Now, the issue which remains for, adjudication in my humble submission matter, for the remainder period, whether I am entitled to exemption of it. Now, my lord, if we go by the scheme of 2005, which has been, my lord, made pursuant to the power conferred under section 94, the power is there. So, therefore, my lord, the decision in any package drinking will not come into this. And moreover, my lord, the commissioner.
The fact that you are not manufacturing is not in doubt.
No, my lord. In view of the decision in any package drinking water, certainly I cannot make any submission of that. Perhaps I am stopped to make use of. But question is, when my lord, the industry was running prior to 1/5/2005, that is coming to force at the time. Then my lord, the issue is whether I will continue to get the benefit till the end of the year. That is the issue, my lord. Now, if the lordship would kindly permit me to. Lordship will kindly take the petition.
Why there are two matters?
But actually, I am appearing in item for one. Okay, my finger will come in explain matter. Now, my lord, you kindly take the repetition.
It is 6977.
One second. Yes. Okay, kindly come to page number 49.
Yes.
I will be reading my lord second subpara, Mr. Saraf submitted.
Mhm.
Mr. Saraf submitted that the impute reassessment order refers to the judgment of the Honorable Guwahati High Court in any package drinking water, wherein it was held that activity of producing packaged drinking water does not amount to manufacture. Advocate Mr. Saraf submitted that the review petition number in respect of the matter of the application before the Honorable Guwahati High Court. Moreover, appeal under consideration involves the question whether appellant dealer is entitled to tax incentives under 2005 scheme, irrespective of the fact that the industrial activity of conversion of raw water into drinking water does not amount to manufacture in terms of section 230 of the Act. As this aspect was not discussed in the judgment, in the associate judgment, the same does not apply in this case. Mr. Saraf further submitted that the London Superintendent of Taxes has not taken cognizance of the judgment passed by the Honorable Commissioner of Taxes in case of Vivek Stone Crusher Industry, wherein he allowed tax exemption remission in case of a finding that the same dealer has availed the tax exemption on the 97 scheme, and so he was entitled for the same under 2005 scheme. Mr. Saraf strongly pleaded that the appellant dealer is entitled for 99% tax remission under 2005 scheme, irrespective of the fact whether the industrial activity of packaged drinking water amounts to manufacture or not, and states that the aforesaid judgment of the Honorable Commissioner Assam supports this contention. I find merit in this pleading. And finally, kindly come to the next page. On top, I am further of an opinion that the impute assessment order is passed without taking cognizance of the provision contained in clause 2 and 4(1) of the Assam Industries Tax Remission Scheme 2005. Clause 2 of the same scheme states that an industrial unit which is or was in commercial production before commencement of the Act was already found eligible for exemption under Assam Industries Tax Concession Scheme 97 as per eligibility criteria of the industrial policy of Assam 97 or industrial policy of 2003 LPT shall be treated as an eligibility. Clause 4(1) of the same scheme is already introduced here in the law, and I also observed on perusal of the prescribed form of the application for grant of certificate of entitlement, and there is no column wherein details of the product manufactured by the eligible industrial units are sought. Consideration of this provision leads me to hold that it was legal obligation of the London Superintendent of Tax to dispose of the application for grant of certificate of entitlement filed by the appellant dealer on 21/7/2005 prior to passing of the impute order, and as a result, the impute order passed is premature and is liable for being annulled. On perusal of the provisions of clause 2 and 4(1) of the aforesaid scheme, I found that those units which are eligible under Assam General Sales Tax Act were issued certificate of authorization are to be allowed to enjoy tax remission for the remaining period to the extent permissible until either the monetary ceiling or an expert period of eligibility, whichever is earlier is exhausted, even if the industrial activity does not amount to manufacture. The industrial unit of the appellant dealer has started commercial production in effect from 2001, as evidence from the eligibility certificate and certificate of authorization from me. Honorable Commissioner of Assam in his judgment in case of Vivek Stone Crusher Industry Nagaon Health has those units which were eligible under AGST Act and were issued certificate of authorization have to be allowed to enjoy tax exemption for the remaining period, even that the activity does not amount to manufacture under the above Act of 2003. But in case of unit which commences commercial production on to 1/5/2005 or thereafter, tax concession will be permitted only if the activity amounts to manufacture under the agreement. The said judgment was passed on 20th of October 2009.
Mr. Chaudhary, the thing is, what is the power for grant of exemption?
So basically, there is the industrial policy.
Power is not from an industrial policy. The power is from an act.
The power, actually, the policy, reflect the decision of the government to encourage industrialization. Now, when a notification is issued or a statutory provision is made by law, it is basically to give effect to that policy. That's why, my lord,
No, understood.
in some of the cases, Supreme Court has said it's a ministerial act. That's why, my lord, sometimes it will happen. Cabinet takes a decision to give exemption. A particular department, my lord, places the spanner. In Supravat scheme and all these things, Honorable Supreme Court has said that once the policy stands, a particular government department cannot take a conclusion. Because the basic scheme to give government concession flows from the policy decision of the government, it will be from the cabinet.
Now, are you saying that the tax remission scheme or the concession scheme which was there,
That's a statutory provision.
which is the statute?
Yes. Lawsuit kindly, please have this that act.
Yes.
Kindly come to section 19. Sorry, 109.
Yes.
Now we kindly come to subsection 4.
Yes.
In respect of a registered unit which have been enjoying the benefit of sales tax contribution under the Assam Industry Sales Tax Scheme 1997 and any other scheme immediately before the appointed date, and if it have continued to be so eligible for any period which is to end after the appointed date, had this act not come into force, the government may formulate appropriate scheme in conformity with the provisions of this act to substitute the said scheme for the period commencing on or after the appointment.
So this is after the period for which the remission scheme came. Now, the right to get under the sales tax concession scheme also flows from the act.
Yeah.
If I'm not wrong, it is under section 9(4)
Yes, right.
of the
AGST.
AGST Act. Now, what does section 9(4) say?
So much.
Section 9(4) says
I think, my lord,
there are two parts of section 9(4). The first part of section 9(4) says about how industry would be eligible. And the second is on the benefits given to the manufactured products. Now, if the manufacturer is not there, how do you bring in?
no, my lord, precisely to take care of that situation, section 1094 is there.
Understood. But then also,
My lord,
you
for
you are getting the benefit on the basis of a scheme.
something like this. There was a promise. Pursuant to the promise, this petitioner will set up. Now, there is also an element of minor whether doctrine of promissory estoppel will also come. Because
No,
my
Mr.
lord,
Chaudhary,
I-
in view of the
promise was-
judgment of the Supreme Court in Hero, that Hindu Hall Corp or something, and the unicorn, there cannot be any promissory estoppel against the statute.
My lord, but then, my lord,
When the
right from-
statute categorically
Like from the
says,
Punjab case, SCA and all these cases, where Supreme Court had said, my lord, until and unless you restore the position, you cannot take away vested right which you have promised.
but then also these are the latest judgments where it has been dealt with after taking into account.
What I'm saying is, my lord, for for an activity which commenced after 1/5/2005. If it is not manufactured, then there is no question. But for an activity which commenced prior to coming into force of the Act, I think by virtue of subsection 4 of section 1, their right will continue to be given. And my lord, precisely under this scheme has been framed. And you have a look at the.
But in this case, you have not been issued a certificate of entitlement.
No, it is there.
No,
Authorization. Authorization is
no, no,
there.
authorization.
Ah.
See, authorization was under that scheme.
Ah.
This,
No, no, my
under
lord.
the sales tax concession scheme.
That is our case. The assessing officer, my lord, he should have considered my application, which was filed on.
Now, can it be considered when it doesn't amount to manufacture?
No, no, yes, kindly see, my lord. But also to kindly come to the scheme. Revision scheme, and in the eligibility reply, we have connected. At page 144.
Yes. Yes.
Lordship will kindly come to my lord 143. In exercise of the power conferred by subsection 4 of section 109 of the Assam Value-Added Tax Act, the governor of Assam is pleased to frame the Assam Industry Sales Tax Remission Scheme 2005, substituting the existing Assam Industry Sales Tax concession in 1997 for continuing the conferment of benefit being enjoyed by eligible industrial unit under the Assam Industry Sales Tax Concession Scheme 97 by a remission of tax to those units in conformity with the provisions of the Act in the manner thereafter appearing. Namely, Mother will kindly come to 2. An industrial unit which is or was in commercial production before commencement of the Act and was already found eligible for exemption under Assam Industries Sales Tax Scheme 97. As per the eligibility criteria of the Assam Industrial Policy of 97 or the Industrial Policy of 2003 as the case may be, shall be treated as an eligibility. It doesn't talk about the Act and all. It says an unit which was earlier getting the benefit under 97 scheme, then that has to be constituted eligible. But my lord will kindly come to 4. The eligible industrial unit holding a certificate of authorization issued under Assam Industry Sales Tax Concession Scheme 97 as on the date of commencement of the Act shall make an application in the format 1 appended to the scheme to the prescribed authority within 1 month of the commencement of the Act. Provided that such application may be admitted by the prescribed authority, it is satisfied that the unit has sufficient cause for not making application within the period. Now, these important. On receipt of the application, the prescribed authority, after satisfying itself that application is correct and complete in all respects, shall issue a certificate of entitlement promptly appended to the scheme in lieu of certificate of authorization ordinarily within 30 days. Such certificate of entitlement shall be issued for the financial year only. And this was not done, my lord. We applied. And I think, my lord, the prescribed authority was bound to issue, my lord. And the 4(1)(b) says that once the application is correct and complete in all respects, a certificate of entitlement will be issued. That is our grievance, my lord. That was the argument before the minor appellate commissioner, which that argument was upheld. Before at least my lord making this assessment, they should have considered this as if I am not entitled to this, I should have told why I am not entitled to. That was also not done. Therefore, in my humble submission, my lord, for an activity which commenced prior to 1/5/2005, perhaps, my lord, there is no bar.
Even if it is not manufactured.
Even if it is not manufactured. Now, my lord, I will refer to that order of the commissioner, my lord.
How do you take care of various judgments which have been pronounced by the division bench? Forget about any packaging, the others wherein it has been held. And you had appeared for as the additional advocate general.
Any packaging.
No, all the others.
If a lordship.
Just for example, in this matter,
178, my lord.
no, kindly, if you have seen Sri Industrial Industry, where you have appeared, that is also a case where it is directly covered by your case. Then you have the judgment of Deepak Kumar Poddar, where you have appeared, wherein it has been held, that was the case of mustard oil.
Yes.
And then there also, you see, you may not be. Whatever you have bought, it is okay. But for future, would you be entitled to without the certificate of entitlement?
No, my lord, certificate of entitlement, I'm not, to that extent, I'm not, I mean.
No, we are only concerned after 1/5/2005.
1/5/2005, why you will deny their certificate? Where is that order?
No, how can you be issued that the certificate?
So let them say the reason why I cannot be issued, my lord. They have to say,
No, they have, whether they have said or not, but the fact that as of now, if it is not a manufacturer, how can you be issued a certificate of entitlement?
lordship, kindly come to page 179 of their reply.
Assam General Sales Tax Act 1993. 179.
My lord, will kindly come to page 179.
Yes.
Somewhere in the middle, my lord, it is said, any paragraph is stated.
Hmm.
Limits of tax relation for eligible unit.
Hmm.
Where an eligible unit is holder or is a holder in due course of obligation. Informed so and so. As per the terms of the Assam Industry Sales Tax Concession Scheme 97. On the date of commencement of the act, is registered under the act, shall be entitled for remission of 90% of the tax payable by him, giving the return period after commencement of the act until amount of such remission exceeds the unable quantum of monetary fee or extended unexpressed period of fee, whichever is earlier remaining available to him at the time of commencement of the act. Now, the findings. Hence, those units which were eligible under AGST Act and were issued certificate of authorization have to be allowed to enjoy tax exemption for the remaining period, even that the activity does not amount to manufacture under labor tax.
Where you will be? Page?
Last but one parameter, page 179. Last but one parameter, hence, sentence starting, hence. Page 179. Last but one paragraph towards the bottom.
Yes.
Hence, those units which were eligible under AGST Act and were issued certificate of authorization have to be allowed to enjoy tax exemption for the remaining period, even that the activity does not amount to manufacture under the Act. But in case of a unit which commences commercial production on 1/5/2005 and thereafter, tax concession will be permitted only if the activity amounts to manufacture under Habit Act 2000. So, whether this is the finding given by the highest authority of the parliament. In case of stone crushing.
Stone crusher, this can't be the highest authority when the division bench have held that one is not entitled to. But that is always, that is an understanding of the officer.
Therefore, no, my lord, as an assessing officer, the assessing officer was bound by these orders.
This court is,
Assessing officer.
but can this court go on the question of judicial discipline or out there of these officers when this court is to deal with a particular question?
Assessing officer relies upon any package. Any packaging is not a case, my lord, which involves period, which where the prior to that also they were enjoying the benefit. Any packaging drinking, facts are not similar like us. They are the production comments after my lord 1/5/2000. And even in any packaging, my lord, if a lordship will have the.
No, but can you say that there is a promissory estoppel out there?
No, if a lordship will kindly come to that any packaging for a moment.
You are referring to paragraph 18?
Last paragraph.
Yes, 18.
I think the Central Department's affiliated they were next week.
No, that I read it. That day your junior has shown it to me.
Yes, yes.
That is on the question of as to whether there was as regard the change of opinion.
Yes.
Now, if it is a change of opinion, then you cannot change that you cannot say that he is not entitled.
My lord, there are two other judgments of the Supreme Court on this point.
Yes,
Can I clear those? My lord?
yes.
First, my lord will have 2005 6 SCC 292. Badilal.
You have given the list of books. Okay, you read it. Yeah.
Therefore,
No, there is a book out there. AGST. You have the AGST. You see, the power therefore is under 9(4).
yes. My lord will.
If that power, the power on the basis of which this scheme, because you are getting now the scheme which has happened thereafter is the tax remission scheme has come in view of 109. And prior to that, the tax remissions, the concession scheme was based on 9(4).
Yes.
9(4) states about two things. The benefit can be got,
Yes, yes.
may be specified in such scheme and producing such goods.
Yes.
And on manufactured
In
goods.
fact, that precise aspect is there in this case, my lord. Can you have a look at this? My lord, the pages may not tell you. I am holding my lord SCC. In my citation, it is para 20. In this case, I will start with that, my lord. In this case, State Sales Tax Act. In this case, this State Sales Tax Act contains process profit. Yes. In this case, State Sales Tax Act contains no provision relating to manufacture. The concept only finds place in the 1993 government order issued by Department of Commerce and Industry. It appears from the context of other provisions of 1993 government order that what manufacturer has been used to exclude dealers who merely purchase goods and resold the same on this retail price. What the state government wanted was investment and industrial activity. It is in this background that 1993 government order must be interpreted. The Department of Commerce and Industry has by its second details clarified the issue. Exemption was granted in terms of 1993 government order, the thrust of which was to increase industrial development in the state. The Commissioner Commercial Tax had also in no uncertain terms accepted interpretation put by the Industry Department on 1993 government order written to so to permit sales tax exemption to applicants in accordance with the Government of India order for a period of 5 years or up to the limit of rupees 35 tax. Now, Madam, we kindly come to para 20. Furthermore, under the incentive scheme in question, there was only one method of verifying the eligibility for various incentive granted in sales tax. The produce was for the matter to be scrutinized and recommended by state level committee and district level committee and certification by the Departmental Industry and Commerce by issuing and eligibility certificates. There was no other method prescribed under the scheme for determining industrial units eligibility for the benefits granted. The Department of Industry Commerce having exercised its might and having granted the final eligibility certificate, which was valid at all material times, the Commercial Tax Department could not go beyond the same. More so when Commissioner of Sales Tax has accepted the eligibility certificate issued to the appellant and has separately notified appellant's eligibility for exemption under the 1993 government order. In these circumstances, DCCT certainly could not assume that the exemption was wrongly granted, nor did he have the jurisdiction under section 20 of the Act to go behind eligibility certificate and embark upon a fresh inquiry with regard to appellant's eligibility for grant of benefits. Para 23. There is another reason why action of the BCP cannot be upheld. The primary facts relating to process undertaken by the appellant at its unit were known to the Department of Industries and Commerce and DCC. The only question was what was the proper conclusion to be drawn from this. Department of Industries and Commerce, which was responsible for issuance of government 1993 government order, accepted the appellant as an eligible industry for the benefit. Apart from the fact that it can be assumed that the Department of Industry was in the best position to construct its own order, we can assume that in planning the scheme, granting of eligibility to the appellant, all Department of State government involved process has been duly consulted. State which is represented by department can only speak in one voice. Having regard to the language of the 1993 order, it was the view expressed by the Department of Industry, which must be taken that to be done. Now, my lord, since it is the industry department who frames the policy, my lord, and since the authorization was given, the commercial tax department cannot take any position. Here also the issue was with regard to, my lord, other than one who whether only manufacturer will get the benefit.
But the sales tax concession scheme was done under 9(4).
My lord,
Sales tax concession scheme was on the 9(4).
initially,
Yes.
but subsequently under my lord 1009.
Subsequently, it was carried forward under 109.
So, my lord, kindly appreciate the factor from this end. Literal interpretation of section 9(4), which was lordship is correct. But my lord, there is a lot of difference between section 9(4) and 230, which came to be, my lord, when the word manufacturer came to be defined with, my lord, that. Now, my lord, the act was repealed by VAT Act. In the VAT Act, this new concept has been brought in. If anything does not amount to manufacture, then it will not be considered as eligibility. There is no dispute. But we are confronted in a case where the activity started prior to the coming into force of the VAT Act, when the benefit was otherwise, allowable matter. Now, what will happen post 1/5/2005? Now, the departmental circular says that despite the fact that this is not manufactured, if you are otherwise earlier eligible, then you will continue to get the benefit for the period for which it was given. Now, my lord, the question is, what meaning lordship gives to the transitory provision incorporated in section 109? Now, the scheme of 2005 is expressly framed under 1094, and it says an unit which was earlier eligible will be constituted to be an eligible unit under the 2005 scheme. So, in that view of the matter, my legislative intent is also very clear. That
But a unit has to be eligible.
yes.
But whether it is eligible because it has not manufactured or produced.
That's what I'm saying. For an unit which commences its production after 1/5/2005 is absolute. If it is not, will not get. But for a unit which started its production earlier, then what happens?
So you are on the basis of promissory estoppel.
Of course.
Now, therefore, in the case of Hero and Honda Corp for that judgment, the Supreme Court, taking into account the judgment of Unicorn, had categorically said, here what has happened. There were certain exemptions which were being granted.
Hello, can I make a
Yes.
that promissory estoppel I didn't come prepared. But also kind of give me 15 minutes time after tomorrow, my lord, I can clear on that. Otherwise, my lord, my argument is this. 15 minutes time on my lord, Thursday, my lord, I will come.
Because you need to address this quote on Deepak Poddar.
Yes,
Because Deepak Poddar categorically holds that one has to be manufacturing or producing to be eligible. And that was the case of raw mustard oil to mustard and filtered mustard. So there section 9.4 was taken. Now thereafter comes 109. Understood? If they were given, because the entitlement here is a case where the entitlement which the petitioners are seeking is after 1/5/2005. So therefore, he has to have a certificate of entitlement. You see that in view of the scheme, in terms of section 2 and section clause 2 and clause 4, he is automatically entitled to, on an application, is automatically entitled to the certificate of entitlement. But the question is, would he be entitled, or because there are various judgments of a division bench out there, wherein it says if there is a question of change of opinion, you cannot touch on the certificate of eligibility. But
if it is a false statement, misstatement, etc.
but if there is a case where it doesn't fall within the ambit of manufacture, or if without the manufacturer, because you are getting the benefit, yes, for those period you may not.
Perhaps Lakshmi also has to look into another aspect. Now there is no dispute that because of the incentive the industry was set up, investment was made, employment generated. It's a different matter now is to matter. So has it not served the purpose of the industrial policy by establishing the industry? I think that is another aspect which perhaps will have to be given a meaning because of this judgment. Well, this aspect is, taken note of, not very conclusively, but this aspect is taken note.
But
Let's
this
develop this point.
is a judgment where the question of manufacture, there was no definition of manufacture.
It's a government order which provided. There's a subsequent judgment also, my lord, of 22nd. I'll place it on day after tomorrow, my lord. Let me also come up prepared on that, my lord, promissory estoppel part.
Because what has happened, all these promissory estoppel judgments which have been there, in view of this Hero, Honda Corp as well as Unicorn,
That, my lord, there cannot be any estoppel against law. That's a settled position. But my lord, when it comes to application of doctrine of promissory estoppel, the view of the Supreme Court, my lord, has been slightly different.
because that was a case, Hero, Honda Corp, that was a case, what has happened, initially they were getting benefits. Now comes the GST. Once the GST came in, that particular notification which was there, that was removed. And the notification which was there had to be extended, was not extended, was removed. And under such circumstances, by section, I think 174, under such circumstances, what has happened is, they challenged it on the ground that we have a promissory estoppel, we are entitled to this period of it. Then the Supreme Court said on 2 grounds on this.
In this case, the industry department stand until they file the affidavit was different. When in the affidavit, they have not withdrawn the authorization.
No,
Now,
eligibility.
yes. Now, the example which your lordship has given in case of after coming into force of the GST regime, government at least expressly came up with a stand that henceforth nothing. Here, my lord, such a stand is not there. Only particular department of the government is trying to put their spanner. Here, my lord, the unified stand of the government of Assam is not before lordship. That is the distinction, my. Yes, I can appreciate if after coming into force of the Event Act, if industry department would have taken a call, then now because of section 230, the definition of manufacturer has been given a different dimension altogether. Therefore, we review our policy and therefore, my lord, we withdraw all these concessions.
No. Where is the question of withdrawal?
No, they have to take a stand that even the union whose period has not expired or the amount is not fulfilled, they are also not eligible. There is no stand from the government of some minister industry. There is no stand. It is only the commercial tax or the sales tax department who is taking this stand.
Because the sales tax department is issuing the certificate of entitlement.
So they neither denied mine. They simply said over it. And my lord, on the promissory estoppel part and all, I was there at 2 o'clock also. I left it to my seat.
Huh? Can it be on? No, you make your arguments. Let us hear you. You are ready today. He has only something to say on promissory estoppel. And your arguments, what you are going to make, I will counter it on that day, if you are not there. Or Mr. B. Gogoi is there. He's also from finance and taxation. He will make submissions to them. Yes, you make your submission. But anyways, the fact that you have not issued the entitlement certificate is there. So you have not till date. That is there. And what else? What argument do you want to make? Or did I make the arguments on your behalf?
The last reason proceeding, if it is not disposed of, lawsuit intended to
Not necessary, because you are, what will happen, I know. Yes, you are ready. Any more?
otherwise the manufacturer definition has been.
That I have taken care of.
Subsequently, there was also a review application for that order. That
Any
was-
packaging, any packaging,
Any packaging for review of the any packaging.
that was dismissed.
Yes.
No, his submission is different. He says yes, the fact that it is not a manufacturer is not in doubt. He's not arguing on that. But the fact that he was given the benefit earlier, earlier scheme, and as such, by virtue of 1094, read with the remission scheme, he is entitled to because he was enjoying the benefit earlier. That is his argument, precisely.
And also under the other policy, it has to be the certificate of authorization. It has to be reviewed each year.
But we are not concerned about the period prior to that, because here I think it is period after 1/5/2005. We are concerned. His argument is therefore space, although there are many things, it's simple to that effect. Then look here, I was given the benefit, and by virtue of a statutory provision, section 109(4), a person who is getting the earlier benefit, he gets the benefit. And as such, they could not have denied me the certificate of entitlement as well as not taken into consideration that I am eligible. That is his submission. What is your argument on that? He says that any packaging is for a period after 1/5/2005. And as such, it does not take into consideration this aspect.
The earlier instance of the certificate of authorization.
Lots of kind permission.
Both of them mistaken of a lot, because the definition, what the things for that they are producing doesn't involve any manufacturing. That has been our stand in the executive process. And on that basis, the assessing officer assessed.
No, that is okay, but his argument is specific. That if he is entitled to the benefit under the earlier, prior to 2005, and he has got the benefits, by virtue of section 1094, those people who were getting the benefits could be entitled to the benefits under this remission scheme. And as such, the word shall, which has been used in section 4, clause 4, also mandates that he is entitled to a certificate of entitlement. And if that is the certificate of entitlement having not been issued because of a laxity on the part of the department cannot do this revision. That is his submission. Isn't it? So he's not on the question of manufacture or no manufacture.
Lordship, our State Department stand is that initial.
What have you done for the period prior to that? Prior to 2005, what have you done for that?
For cancellation, Lordship,
No, not for cancellation, for sumo to revision.
Lordship, that.
So your argument is again on manufacture. Yes, you are the main person. You have created all the problems.
Your Lordship, the case they have made out initially is that in two aspects. First is that what they are saying is that though it's not a manufacturing unit now, because I was given the benefits under an earlier scheme. So in spite of now the error has been pointed out, error has come up and it has been taken into cognizance by the department, you will have to give me that benefit which I was giving under eligibility certificate. And if I could understand properly, Lordship, that they main case, the whole case is based on this case of this Vadilal's case.
Not Vadilal. Vadilal, he has shown it, but that is Vadilal has no relevance.
No, Vadilal has a relevance because Lordship, I will show it to you, your Lordship. Because Lordship, in the Vadilal's case, what happened is that Vadilal's case that
Vadilal's case says that if the industries department issues the certificate of eligibility, the state says department cannot say no.
that is one aspect.
And what else?
Another factual distinction was there. The factual distinction was that at that point of time, that scheme was already expired. In this case, the scheme is already there. When the error was found out there, at that point of time, the scheme is already expired, and they wanted to take back the money. So in this case, it's not like that. When the scheme is already still on, the error has cropped up. Now, what the department is going to do? When there are judgments from the dishonorable court, that manufacturing part, as far as if the industry is not involved in manufacture, then you cannot claim it. Now, in this case, also there are they have basically produced three things: one, bottling of water; second, PET jars and soda water.
Second,
PET jars, the small jars for these things, PET jars, and then soda water.
so there you are giving.
So in our district, we are giving them. We are saying that like if you are manufacturing those and selling those, you give us the evidence, you will get it there. Only thing is
What
that
about the argument which you can make that the benefit under the scheme was only given from the start of the commercial production? And if there is no commercial production, there is no production, where is the question of getting the benefit?
if there is no commercial production, then obviously there is no, if there is no production, there is no manufacture, there is no sale.
No, Mr. Golda.
I'm not getting it that way.
Production is a different word altogether.
Okay, now see this.
Manufacture is different. A
That-
production may include a manufacture,
Correct.
but manufacture may not all include the production.
But
Then
here,
what is your, I'm asking you to address on that.
here, it's not production, it's manufacture is required under the scheme.
Is it?
Yes.
Where is it?
Yes, Lord.
Show me that.
But
Where?
we can kindly take up that here, activity in reply.
Affidavit in
Reply,
or page?
page 144, you will find
Yes.
the scheme, Lordship.
Got it.
So number 3, Lordship, at page 144, it says the limit of tax revision for eligible units. Where an eligible unit registered under Assam Railway Tax Act manufactures any good in Assam, other than those declared above are not eligible. 99% of tax payable to such unit. So
according to its return in respect of the sales of the such manufactured materials shall be eligible for remission, continue to be eligible for remission until
This-
the
what has been included in this scheme.
Now, what happened to the eligibility certificate? Eligibility certificate is issued under what?
I mean, when this.
Let us see,
The department has
you
taken-
have issued the eligibility certificate under what provision to him? Under the 2003 or 1997?
1997.
97 industrial, where is the industrial policy?
Policy is not annexed to this.
Huh?
Policy is not annexed to this.
Have you seen it? Hmm?
The policy they are within the clause, that is not annexed.
Where is the 97 policy?
The copy is there. with me.
Give it. So this concession scheme, the petitioner became eligible under 97 or 2003.
97, they were getting the benefit of that.
Oh, somebody gave me something. Yeah. Oh, got it. Yeah. I have it. I can write it. You gave it to me on the last.
Here also, then you see the finished product definition.
Where?
That is a phrase, 19 years.
Of
The scheme also, the policy. Internal phase 19 years also.
finished means and includes the item manufactured by the eligible unit as considered under the project scheme approved by the concern. Let us see how the expansion is definition of eligibility criteria. Chapter 4.
Yes, sir.
Chapter 4 says who gets the benefit.
Yes, also the eligible unit is there.
Eligibility criteria.
Definitions, and also definitions you find that 432, the eligible unit is.
Eligible means only new units set up on or after Iman and existing units undergoing expansion area. So prior to that, what is this ancillary means area which is engaged in the proposed to be engaged in manufacture or production of parts, components?
It says about the finished product.
Where does eligible unit, where is it say?
The eligibility also only talks about that, I mean, it doesn't talk about the manufacturing part, only talks about the, I mean, literally talks about the finishing product.
Where?
The place, the 19-year also, the finished product
That is a definition.
definition. Also.
Then
Industries, those are set up. And they come up with this production, finished product. The finished product has to be come out with the process of manufacturing.
4.5 is a certificate which shall be issued by the Udyog Sahayak of the destructive for SSI industries in Assam, so and so for the medium and large scale. This will be issued after ensuring that all criteria for eligibility have been fulfilled to the full satisfaction of all. No right or claim for any incentive under the scheme shall be deemed to have been conferred by the scheme, mainly by virtue of the fact that they have fulfilled all its part.
So also departments,
The scheme incentives and the claimed under. Oh, yeah. Sales tax exemption as per chapter 5.
yes, sir.
All new units and existing units going on for expansion, diversity and modification will be granted sales tax exemption for sale of finished products and purchase of raw materials as per the following scale.
So finished product refers to the definition of finished.
So you are saying what? As per the 2005 also, it has to be manufactured.
So as for 97 also it has to be manufactured, but only thing is that there was a mistake committed by the department, and it has come to the light when the VAT came, and in the VAT, the definition has been specifically mentioned, manufacture, and the scheme of revision has been made, and there also this concept of manufacture has been brought in. And when they apply for this entitlement, then this has come to the notice of the department, as well as that there was a case which has been decided by the Kerala High Court, wherein this it has been specifically stated that bottling plant and refilling will not be termed as manufacture. So
Why do you need to go to Kerala High Court?
no, there was a judgment on the earlier to that. Earlier to the Guwahati High Court judgment, there was a judgment in Kerala High Court. So he says so. So because of that, this tax officer.
So you took the decision on the basis of the Kerala High Court?
No, that judgment has come to the public. So look, that has they have also looked into that also.
No. Are you saying that you
No,
took
no,
the
I'm
decision
saying
on the
that
basis of the
was-
Kerala High Court?
No, that bottling plant thing.
Why are you referring to the Kerala High Court then?
No. What I'm saying is that was it was manufactured.
Because here is the case of change of an opinion.
No, it's not a process change of.
Is it a change of opinion on the basis of the prevailing law, or is it a change of the opinion and the mere wish? That is the reason why.
It's not a mere.
So why? So how did it happen? Is it because of any?
No, but the approximate kindly see them, I'll take the lordship. First notice that has gone from text. Approximate kindly have a look.
Where? Where?
That's in phase 32.
Page
Page 32 of the.
2 of the repetition. Yes.
Fair readers.
Hmm.
The case for making this escape assessment has arisen on the following facts. The dealer filed an annual return with certificate of audit account for the year within the prescribed time, and hence it was treated as a case of self-assessment return within the meaning of proviso up to section 35 of the Act. The dealer ran an industrial unit with the activity of packaging drinking water after filtration of raw water, along with production of soda water, PET bottles and pouches, etc.
Hmm.
The manufactured PET bottles, pouches, etc. were mostly utilized in packaging purified drinking water. The industrial unit had commenced production during the Pascal AZST regime and was issued eligibility certificate and consequential authorization certificate. Subsequently, a mistake of law was detected while issuing the eligibility certificate to authorization certificate after becoming aware of the judgment of the Honorable Kerala High Court in the case of so and so. In as much as it was held, ruled therein that activity of conversion of raw water into packaging drinking water did not amount to manufacture, and hence no industrial sales tax concession can be claimed thereon. When the dealer was issued notice on so and so, contemplating.
So you took the decision when?
This
2008.
this was sent on 31/3/2014.
No. When did you take the decision to change it? That packaged water would not come within the ambit of manufacture.
So
Although the judgment of the Kerala High Court of 2003, but you first took the decision in 2008.
yes, sir. Yes, but this notice was subsequently sent, of course, because certain other because they have applied for this.
No, their submission,
Loss.
Mr. Kulta,
No,
other
loss.
things is okay, but you see, how do you take care of their submission? That they were eligible till 2005 by virtue of the certificate of authorization and the tax concession in which the state sales tax department as well as the industries department have category club. Thereafter, by virtue of section 1094, those people who were enjoying benefit under the earlier scheme.
That will be getting benefit under that subsidy. That is true. Lord.
So therefore, his submission, the vesting of the benefits upon the petitioner is by virtue of 1094. And as such, the sales tax department was bound to give the eligibility certificate, the certificate of entitlement.
Lordship, my response to that will be, Lordship, they are getting the benefit. There's no doubt about section 109 by virtue of 109.
But can't you argue on this? That the definition of manufacture in terms of section 230 under the VAT Act relates to had come into effect from 1/5/2005.
Absolutely.
And as such, the manufacture which is mentioned out there in the remission scheme has to be read with section 230. So unless and until, so any benefit got under the earlier act by legislatively have been taken away.
Obviously, that is one of
I'm asking you, can you make that submission?
That is, in fact, Lordship, we have taken in the affidavit. That's
Have you taken? Show me.
the Lordship thing is that Now the new legislation has come, which has a new definition there. And that has to be, and like, after the ban has come, the legislature has taken care of their definition and they have got this definition implanted in their scheme also. Now, after this has come, now only thing was that like interpretation, what is the manufacturer? That was, that admittedly there was some confusion there of the department also. Then this NEPKZ case happened, then this Kerala High Court case happened, then they have come to the clarity that High Court, the Honorable High Court also has also said that this bottling plant cannot be a manufacturing process. It cannot be a process of manufacture. So that is why the department has taken a decision at that point of time. Though these manufacturing words were there were some confusion, there was no doubt about this was admittedly. So when they have come to know about that they have committed a mistake, now there are some remaining periods are there, and the scheme is still in existence. So what is to be done with that? Now, what they are now saying is that.
So you have taken the action retrospectively.
No, we are not taking the sentence to say that we won't be able to also. But
When did you start the this thing? Assessment, you have done it in 2014.
No, Lordship, as far as the notification about this thing that those processes started earlier than that. Because Lordship, this.
The notification I have seen, but what actions have you taken upon the
Because
petitioner?
after the notification was given by the industry department, they had come across this honorable court. And honorable court has given a stay order. So because of the stay order, then neither the department, industry department, nor the finance department.
Ooh, notification came in 2008.
No, but notification came from the industry. The eligibility certificate was issued by the industry.
No, notification came from them.
No, there was a notification by the industry department.
Regarding?
It's saying that bottling plant will not be of all the bottling plants. Industries, units, those who do not get benefit of this.
When?
There is a notification from the industry department.
When?
I'll just tell you. This was in 2011 years.
So 2011, by the time his period is over. Isn't it?
Yes. Yes.
Maybe he may not be entitled under the pipeline scheme.
It is there till 12. It is there till 12. It was there till 12.
No, that is as regard the pipeline. Because his period must have finished up by 2011.
2005 for another 7 years. So they have started that because they are claiming on that expansion. Commercial production happened in probably in 2004. So another 7 years. Now, let's see that in by a couple of years also. The only question is that when the department has come to know that there was an error committed by them, whether they will be allowed to take the benefit of this scheme, and whether the state exchequer will be given to them, in spite of knowing that there was a mistake on the whether the department can take it.
So how is the exemption notification to be taken into account, interpreted? How is the exemption notification required to be interpreted?
Yes, I mean, so the legal issue is only.
That is the legal issue. How it is to be interpreted? Exemption notification.
Exemption and modification.
How an exemption notification is required to be interpreted?
The exemption notification.
Purposefully? Literally? How?
The exemption were given from the payment of the sales tax. And they are not supposed to take. No, I'm not getting it. Then what?
How are exemption notification?
Yes,
He is getting an exemption on the basis of the scheme.
Scheme, yes, correct.
How are you going to interpret it?
No, that has been given. I mean, once that was issued earlier. Now, entitlement certificate will be given time to time. I'm extremely sorry, Lord, that what your city is basically asking from me. And
There is a 97 scheme.
97 scheme here also.
How do you interpret it?
The 97 scheme also that lawsuit that I.
Or the remission scheme, how do you interpret that scheme?
In that scheme also lawsuit that manufacturer.
How?
Part was there.
Should it be interpreted purposefully? That what Mr. K. Chaudhary was submitting. That you see, what was the basic intention? The intention was let these people be established so that there will be certain.
That, lawsuit is asking about that. I'm extremely sorry.
Very good.
That lawsuit, that policy, of course, lawsuit, that there should be industrialization, there should be economic growth. And economic growth will happen when the industries will come.
How
and
do
they
you
will get the
interpret?
benefit.
How do you interpret?
So-
His submission, it has to be done purposefully. That with a purpose. What is the purpose? There is an industrialization.
But-
And they have already given employment to many, which is the requirement. They have also generated revenue to the state. These are things which they are saying. Now, should we interpret in that manner?
What I would
Then,
say is that
then how do I interpret it?
I would, in that connection also, I would say that there is a statute under that scheme was made, and there are specific industries, there are specific units, if those only who qualify under that, those only get the benefit, and it has to be read with that. I mean, you cannot give a very.
Because you have given a negative list.
No, I have given a negative list.
So
but that
thereby
has
you
been-
are excluding those.
No,
Just for
I-
example, you are excluding coal production of Wasco.
That has been done looking into the industrial scenario in Assam. Which kind of industries are happening there, which are operating there, and which.
So how does this court have to interpret
Now,
our scheme?
lordship, that only because it was not there in the scheme. I apply for this, exemption, I will get it, that cannot be an argument.
Mr. Kalita, you have not understood this court's question.
No, I got it, lordship, that what.
How does the court have to interpret? Should it be done purposefully? Because his basic submission is that. And look here, what was the basic idea of have industrialization in the state of Assam, which will generate employment? We have done that. So under such circumstances, give me the benefit.
But that cannot go beyond the scheme and beyond the statute. The statute say that.
Because all along, till you came up in 2011 or 12,
That is fine. So I-
they were under the impression that from raw water, making it mineral water or the distilled water or water, packaged water comes within the ambit of manufacture.
But that was their impression also that.
And for that, you have
they are
to,
liable
not
to-
only that,
they are liable
no,
to-
Mr. Filter, that it's not only that it doesn't stop there. You have put the stamp of authority by issuing a certificate of eligibility, stating that this is the manufacturer which they are doing. They have given a certificate of authorization, putting a stamp of authority that look here, we have given you for these, whatever things you want. So you have given it. And he continued.
That is
And
correct.
one fine morning in 2011 or 12, you say, no. Yes, it may be prospective, but can you do it retrospective?
Also, unlike otherwise also like what they are doing,
Hmm.
their industry is no longer there. I mean, they have already.
I'm not concerned with their industry. We are concerned at that period.
They are agreeing that they have come up for economic growth and all, they're giving this thing, that they're not, I mean, that their property is no longer there most probably because. They have, I mean, they
You have not given them the exemption, so they must have left. They should still remain.
Yes, lordship, in 1997 scheme, though the manufacturer was there was some confusion because they were also, I mean, in their application also, they have not stated about like how the process happens actually, how the manufacturing thing happens.
Why will they mention?
That those things were
When
not
you
there.
have given a stamp of authority, yes, he is entitled to. See your eligibility certificate.
Yes, sir, lordship.
See, what is your eligibility certificate say? Let us see that. Where is that? Yes, kindly see, page 24, NHRA. What they are going to manufacture, let us see.
That is drinking water, PET bottles and PET.
Date of commencement of production 24/2001, land manufacture finished products. Finished products as per you is packaged drinking water. Then
Yes, but there was a
you
distinction.
have categorically given in 24/2001 to 19/4/2008.
Yes, that is admitted.
Then the certificate of authorization also says packaged drinking water.
That is true, also. That is that.
So he continued. And one fine morning you say, you see that you must have, somebody must have flipped the pages of the Kerala High Court judgment and saw it. Oh, this is the judgment. Why should we not? You have taken the decision in 2000 and that too a decision of 2003. And you took up the issue in 2008 after his period is over. Yes, he may not be entitled for the pipeline because there is no management. But prior to that, did you inform him?
The only thing, Lordship, I mean, I can state before the Lordship is that when the error was found, the department took a decision.
The error was found in 2008.
Yes, sir.
Now, could that decision be taken retrospectively?
Because the Lordship, the other case was also pending that pending High Court, any package case was also.
Any package came after your notice on the 2008. Then. But you have not answered the point which Mr. Chaudhary has argued.
That is Lordship, the policy, as far as policy is concerned, I cannot Lordship say that is not the policy. That is the policy, that is correct. But thing is that Lordship now.
No. His argument is very specific. And look here, let us not take into other aspects of the matter. By virtue of 1094, I am entitled because I was getting the benefits.
Oh, yeah, I mean, that Lordship, we are not denying that they will not get.
Are you saying that you are accepting his argument?
That there is a condition. What I'm saying is that under this scheme is, of course, like 2005 was of, since they are getting under that scheme, other scheme, they will get it here also. That is not doubted.
Are you saying that?
But only thing is that like now, since that manufacturer thing has come out.
Manufacturer was always also there, defined in the AGST Act also. AGST Act had defined at section 222, if I'm not wrong. Yes, I still remember 222. Divine then manufacture with all grammatical variation, cognate expression means producing, making, alter, extracting, altering, or ornamenting, blending, and all whatnot. So, are you saying that in the VAT Act for the first time, manufacturer has come?
No, what I submitted also there was some confusion about this in the department, and when the VAT Act specifically brought in. And the scheme
No, there's no brother. It is the same definition which is there in 230.
Brought in specifically, and like this Kerala High Court judgment came.
Kerala High Court judgment came in 2003.
That came to the notice of the department.
Later on.
So what I also say, like on the face of it, that scheme and the VAT Act, the definition is there. Also, we are agreeable to give them benefit under the for PET jars and soda water. Only thing is that the bottling thing is concerned, and then we are saying that since the definition has come up and it has come to our notice, there was an error committed by us. So like let the error.
But what have you done? You have taken a decision in 2012.
So there was they had come to the court, so there was a stay order. So
when?
They came to the court in 2015.
15. And you have taken the benefit of from 2011. Hello. 13th part, list the matter again on Thursday at 2 p.m. Mr. Sarah, I am not still convinced with Mr. Chaudhary's argument. I had to spend time till 11:30. That is why I was pulling his leg. Yes, Mr. Chaudhary. It will help.
I'm told by them that they engage in this matter.
Hmm?
I'm told by them. They have to distinctly engage in this matter and you keep some time to come up before. For my not preparing the matter.
What is the matter about?
The matter is about my lord some workers in the Earthwell Associate Textile Corporation. He might have dismissed from service, it's the abandonment of the services. Then thereafter they had approached the labor court. The labor court has reached the agreement. And evidence that is type of here. And my lord, the main projection might have been a top of the corporation. Number one is that the Associate Textile Corporation is now no longer in existence. This is known my lord. The second matter, there was a delay.
You challenge the labor court's order.
Yes, sir.
Why?
Because there was a delay of 9 years, my lord, while pushing the labor court. And that delay was not, my lord, considered by the labor court, my lord. And then the directions were given for reinstatement, etc., without taking into consideration the fact that the corporation itself is non-existent now.
Was it brought to the notice of the labor court that when?
After.
At the request of the learned counsel for the respondent who submits that he had been newly engaged in the matter. Is the matter for on the matter stands adjourned for today to be listed again on 14th of November 2023. It is made clear that no further adjournment shall be entertained, taking into account that the writ petitions pertains to the year 2014.
I number 3 for admission.
Madam, the report is against you.
Trying to pull my leg down, your lordship.
Mhm.
Trying to pull my leg down, your lordship. Then your lordship, formally with permission, I would absolutely submit that no one report my favor. Lordship, it is
Those were the persons, those were the persons who were very much your choice.
It was a common choice.
No, understood, but then also these happened out there.
That during the discussions with the commission, my little friend Mumbai was unable to be there, but one of the juniors was there on the first occasion when we had the interaction with the commission. And when we defined about the fact that they should take evidence, they were not very inclined to do that, number one. Number two, when I placed the fact about the difference in the time from which she was brought to the GMCH and till the time that she was sent to the pediatric ICU, the gap of about 14 to 16 hours. That was something where both doctors were fine. I mean, when we were having a discussion that perhaps that was the time when something might have been able to be done. But considering the state infrastructure and the fact that such facilities are not really very readily available in the state, therefore, nothing could have been done about it. But unfortunately, they have not reflected that in the report. So because naturally, we tried to have a very positive discussion, and both doctors have very fairly and very honestly, in fact, agreed to render their services. They apprised us that they would be willing to treat the child free of cost for her entire life, and we're really deeply grateful to both the doctors. But the fact that this particular thing was discussed but was not reflected in the report can perhaps be verified by Mr. Ukumari, the gentleman who was present there before the commissioner. Now, that part, lordships. I can only fall back on the lordship's order of on the last occasion when the commission was formulated, and the lordship had given the liberty of keeping the question of constitutional law. I can only address the lordship. Considering the fact that this report is now on record, I certainly cannot be making submissions against the report. But yes, it is my duty to point out that this factor was definitely pointed out to the commission. That I think Mr. Ukumari, my learned friend was there, and when we were having a discussion, just verify whatever I'm saying. Okay, when the discussions were made before the commission with regard to the pediatric ICU and the fact that the child could not be admitted in the pediatric ICU, there was a vacuum of about 16 hours where she suffered several other seizures as well. That is where they had said that the state facilities are inadequate. That much. That much.
No, no, but there is one thing. Yes, the state facilities may not be adequate. But would that amount to negligence?
This is a where this is the commission has also made. Now, considering the fact that at that relevant point of time, she was having these seizures, perhaps had she been given the
No, was it possible to give? That, was it possible to give it?
quite a lot.
No, no, today, just for example, today, let us assume that nowadays we are having a state-of-art facilities out there, but then also you don't have the same state-of-art facilities which is there out there in Delhi. So, and more particularly in a particular rural area, you may not have it.
A long way to go here.
In places like Nagaon, you still have, the government hospital still has only one ICU. Recently, you can see 2 private hospitals coming out in the the bypass. There were no private hospitals there. If something happens out there, you are kept out there. Either you have to bring it somebody out here to Guwahati and all. This is what is their
It's part of this country.
Yeah.
Not everyone can be elected like a Mr. and be taken to a hospital. But if you have the finances, you are there. If you don't have the finances, you suffer the consequences. And that is exactly where I am as of date. I'm suffering the consequences of a perhaps, I use the word perhaps, a negligence which is never taken note of by anyone about the fact that perhaps had she been given the relevant support of a pediatric ICU at that relevant point of time, she might have been in a slightly better position instead of being 100% disabled as well. That is the only area where I would like to address lordship. Apart from that, I will call back on the submission which I have made with your lordship on constitution and thought and address your lordship on that. Your lordship would want me to address it.
No, not necessary, because in the earlier order by which I have appointed the commission, I have already dealt with that aspect of the matter. For the purpose of constitutional thought, you have a case by which this court can give you. But the question of granting compensation on the question of negligence, it becomes very difficult unless I have some medical evidence to back it.
In fact, your lordship,
And that is why I have appointed the commission.
that at this late stage, they wouldn't want to go into the question of who is making a correct statement and who is making an incorrect statement. And also the fact that, very honestly, they very frankly opine that when a case is happening in front of you, what decision you take instantly is something you cannot, you can find fault with it 110 times later on. But at that point of time, that doctor felt that this was the correct thing. So I'm not even disputing that opinion of the doctor. I'm only saying that the lacunae in sending her to the PICU was perhaps the only small negligence on the part of the authorities during that interim period of 1511 to 1611. Then she was eventually admitted to the PICU on 17th. That is my only case. Apart from that, your constitutional court, I am absolutely at your lordship's mercy in the Upahar tragedy case and the Mulchan Caste Caste case. In fact, there is a very recent judgment of the Apex Court. The question in that case of 2023 4 SCC, I'll just apply about that. But the question there was a little different. That was with regard to Article 19 vis-a-vis Article 21 and how that might have an effect on the state authorities. There, a question was formulated whether even a private entity can be made liable under Article 21 under constitutional law.
Is the constitution bench also?
Yes. So there's a dissenting judgment by Justice Nagaratna. Interestingly, she has taken a slightly different view of the matter. But the majority of the bench has held that even in the case of a private entity being involved, if Article 21 is effective, then these they can be made held back, even a private entity. And that is this is 2023 4 SCC page 1. It starts at page 1, and the majority judgment is at. I'm not bothering you much to the entire judgment. They have tabulated their entire views and opinions, and at paragraph At paragraph 157, it starts logic, 154, 55, 56. This is the majority judgment. And they have tabulated their views at paragraph 166. And thereafter, the dissenting judgment of Justice Nagarata, she has her views and opinions are slightly different insofar as the state partner is concerned. That is good. So this.
But
does not-
how is this?
It is not. It's just that it is on constitution, it is on constitutional thought. They have taken note of the fact that and they have taken note of all the other judgments, which I have also relied upon. Starting from Khatri to Mughal Shah to Lilavati Behra, how the law has developed, all of that has been discussed in detail in this judgment. And thereafter that 5 questions were formulated. This was of course a case where a minister had made some kind of a statement against women and how that freedom of speech might affect Article 21. So that the debate itself was a little different, but the questions which were formulated might have relevance in other fields as well. That was my only mistake. And constitutional thought was discussed in detail in this judgment. That is just the only reason why I want to point it. And apart from that, so far as the quantum of compensation, you also have yourself taken note of that judgment. One was Master Ayush and the other one was Kajal versus Jagdish Chand. So Kajal is one case where again, how compensation can be granted is another aspect which has been dealt with in Kajal as well as in Master Ayush. Whereas.
But Master Ayush is the case where there is a proof of negligence.
Thereby, I fall back upon 2011, the Upahar tragedy case, where it has been categorically held that even if there is no negligence assigned, paragraph 2011. I just should be paragraph 64 if I'm not mistaken.
Which one are Upahar here? Wait.
City versus Upahar tragedy association. 2011, yes. And the relevant paragraphs are 64, 97, 99, 97, 98, and 99.
99.
97, 98, and 99. They were taken note of the development of the law in paragraph 91.
But where is the case where for the purpose of without negligence
So
also?
that is 1997, 97 and 98. Paragraph 97 towards the middle of the paragraph.
This has been drawn from that Upal gas tragedy where it's a case of absolute liability. But would that come within the ambit out here? No, understood. But whether every issue has to be understood on the basis of the facts. But can you bring in here where can you say that giving immunization out there would come within the ambit of hazard risks? Come within the ambit of hazard risks.
It actually is a very, what should I call it, an extremely dangerous thing, because one small mistake can lead to what has happened to me. Or even a small negligence on the part of any doctor could result in fatality. Absolutely. So it requires the highest degree of competence, and it requires the highest degree of attention, if I may say so, by the authorities. And the highest degree of care is what is noted in this judgment. When activities are hazardous and if they are inherently dangerous, the statute expects the highest degree of care And if someone is injured because of such activities, the state and its officials are liable even if they could establish that there was no negligence, that it was not intentional. Now, vaccination is a very important part, and that is why there are so many guidelines. There's a national vaccination policy, which ensures how vaccines are to be administered. There are reasons why these AFPI guidelines have been brought in.
Yes. No, if it is a case of, it's very difficult to say that vaccination, yes, vaccination requires proper care, but does it amount to? Because here the principle which have been implied out there is of the strict or absolute liability which has been given out there in Bhopal gas. When you say that when you are dealing with certain substances which are hazardous, then you have to, if anything happens, there is no requirement of any proof. It is on the basis of that a person is suffered, you have to pay them. That's the concept. Because if this court has to hold that in terms of death, it would amount to a very serious thing which may befall upon the state without the state having the expertise to do that.
In that case, does Article 47 not entail that the state should have the necessary facilities? Only because I'm a poor citizen, I will not be given the proper care and facilities which I be entitled to under the Constitution. Is that my
Article 47 makes it says so that they should be given out there, but then also can you enforce it in a court of law? It is very nice to say, yes, you have to have all these things and all these facilities out there, but then also it has to be seen from the perspective of the state, whether the state is in a position.
I have to agree with the fact that we are moving towards the concept of a welfare state. We have not yet achieved that as not even 50%, I would say. It is really sad to say that although we are on the map of the world right now, but unfortunate as it is, if you come to the country and see the lacuna in our system, they're great. And if I am a victim of that lacuna, what is the remedy which is available? I can only address your logic on that. It is a constitutional mandate. That's absolutely correct. But not all provisions of the Constitution have been able to be reproduced in reality. In fact, there are several laws.
These are the constitutional goals, which may at one day may be.
In fact, that doesn't have just about. There is a very interesting paragraph which 2023. I would just like to place that paragraph because we are having this discussion. 2023 4 SSQ, page 1. Paragraph. It's paragraph 157 of that judgment. It is also started. 2023 4 SSQ, page 1, paragraph 157.
For SSC.
Yes. The first report of the law commission.
Yes. Yes, read it.
I'm just going to read it slowly. In chapter 8, containing the conclusion and proposals, the first report of the Law Commission suggested, number 1, that in the context of a welfare state, it is necessary to establish a just relation between the rights of the individual and the responsibilities of the the state. Number two, that when the constitution was framed, the question as to what extent, if any, the union and state should be made liable for the tortious acts of their servants or agents was left for future legislation. Number three, that the question of demarcating the lineup to which the state should be made liable for the tortious acts involves a nice balancing of considerations so as not to unduly restrict the sphere of the activities of the state and at the same time to afford sufficient protection to the citizen. Thereafter, Lordship, in paragraph 158, they have quoted paragraph 66 of the first report of the Law Commission. The paragraph 66 of the first report of the Law Commission contains the principles on which appropriate legislation should proceed. It will be useful to extract paragraph 66 of the first report of the Law Commission to understand the sweep of constitutional thought as it was conceived within a few years of the adoption of the Constitution. In fact, it has laid down roadmap very clearly for a lot of foresight. Paragraph 66 reads thus: proposals. The following shall be the principles on which legislation should proceed. Number one, under the general law. Under the general law, that is the English common law as imported into India, on the principle of justice, equity, and good conscience, with statutory modifications of that law now in force in India, the state as employer should be liable for the torts committed by its employees and agents while acting within the scope of their office or employment. The state, and there are several others which have been quoted down here.
Yes.
Duties of care imposed by statute. Page 137, second last line. Page 137. Second last line. If a statute authorizes the doing of an act which in itself is injurious, the state should not be liable. This next second, the state should be liable without proof of negligence for breach of a statutory duty imposed on it or its employees which causes damage. The state should be liable if in the discharge of statutory duty imposed upon it or its employees, the employees act negligently or maliciously, whether or not discretion is involved in the exercise of such duty. My only submission before your Lordship in showing this aspect is that way back in those years, when the first Law Commission report had come out, they had how futuristically they had thought about the entire responsibilities which come attached to a welfare state. And now, 75 years after independence, and perhaps 70 years after this Law Commission, can we still fall back and say that we do not have the adequate facilities which ought to be granted to a citizen? And so therefore, I should be not be entitled to anything from the state. That
But
is
the
my
problem is at paragraph 159 of the state judgment,
Lordship.
this was directed, but the fact that it was not, these were the recommendation, but it was not followed upon. It was not made the law.
Very good. As a consequence, a huge burden was cast on the courts to develop the law for judicial precedents, some of which we shall now see. And that is where we are at the Lordship as of now. What I wanted to point out is that the idea of a welfare state in its inception itself, and the Constitution has come into force, since then the idea of the welfare state has been moving. But how far have we been able to achieve it? Even after 75 years, the question is still remains to be answered by the state. Why should I, being a poor citizen, why should I be made the scapegoat of an argument which is being raised that we do not have the necessary facility? Why do we not have it, even after 75 years? This very hard information.
And where all these judgments have been taken in the account in this case, where all these judgments have been.
Paragraph. It starts at paragraph 166. 165. Tabulated chart. 164 they discussed Khatri. Then they went go on to Odisha. And 166, they say that after Buduncha, there was no looking back. And instead of providing double details, we think it's sufficient to provide a tabular form. And thereafter, they have considered all these judgments.
Now, 167. It will be clear from the decision. That I've looked into.
And 166.
Yeah, 167. It will be clear from the decision listed in the table above to this court in the High Court has been consistent with the Constitution of the Commission.
That aspect was also dealt with in the earlier case, also question was the state Mazdoors Committee, which was 1996, and reiterated the negligence on task in paragraph 67 about medical facilities and how the state is obligated to ensure that such facilities are available. This is one case which is not been spoken of by the so the good is only 27.
Which one? Which one? Have you given it? No.
I have joined the copy.
I have Krishna Kumar and I have Kajal, Radha Krishna. Radha Krishna? What is Radha Krishna doing here? Radha Krishna has no relevance of it. Radha Krishna is different. We do Belek. Master Ayush. Work on Huh? Paragraph?
67.
इधर Madam, I will take care of these. This aspect, I'm not anything more than what is this court had for. No, that I will take care of. No, this court taking into account the report would take care of that in her life, something has to be given to her. That is one. The second is the medical facilities which she requires has to be provided to her. These are constitutional duties. Third is the social welfare has to provide all those things. These are there. There's no quarrel with that. Only and if further medical, anything medical and all, which is
So one thing which you might have to address when you're trying to actually pass on the orders. Then the problem becomes that the same people had some.
no, or the what should you see, there is one thing I can very well say. As regards anything more than this, what this court is going to give, I shall leave it open for you to file in the civil court, which this court was initially there.
But then the point is that when we raised this point with the commission, they were not inclined to go into that aspect.
Because it would be very difficult. Because now appointing a commission, the only other way out here is to cross-examine with the commissioner, which I don't think should be done.
This could be a point that we're not sure who would be taking the correct statement. Who would be, because now it has become a very important case. In the village also, everyone knows that this matter is going on. There are times when an ambulance goes to pick up the child. So naturally, it has become a high-profile case. And people are very worried about making a submission which might go against them. So naturally, they likely find that at this belated stage, if we take a cross-examination or if we examine the witnesses, it perhaps might not be able to give us a true picture of the entire scenario. So,
And apart from that, you see, a cross-examination of the witnesses, the commission's report, the commissioner may not be in the interest of the commissioners because they have accepted this, the request made by this court. They have done so. And then later on, if similar cases are there, no doctors would be liable.
in fact, at a particular point of time, the neurologist had opined that by giving her Botox treatment, we always understand Botox to be a cosmetologic thing, but it is in fact a very therapeutic thing, a drug, and it is normally used for treating spasticity. So in fact, he had opined that perhaps by administering her that drug, she might be able to walk a little better. But unfortunately, the decline in her, the degeneration of her muscle is such that perhaps even that might not work. So she would be totally dependent on these are all some discussions which were held in the presence of this human resources. So it is not, although it is not reflected in the report, and I just asked the branch about it. We are absolutely grateful to the doctors for having given us a fair hearing and for having taken note of all our grievances.
Yes, Mr.
How we are going to begin break this fair one regarding the compensation part, only that was what I did on our
No, that report was only for the purpose of ascertaining whether there is a negligence.
That has to stop here. And
Nothing is there on that report as of now. As regards the other aspect, as regards the constitutional, I won't say a constitutional thought in this case, because thought means there has to be a negligence. But I will say a constitutional duty now imposed upon the government to take care of the child for the unfortunate thing which is happened. For that, this court is going to pass, I'm saying it, shall pass an order by which monthly some stipend has to be given out there, which I had earlier said, as well as also this is the medical, not this Ayushman and all these things, but the medical facilities whenever she requires out there as per the prescription of whatever may be.
We have admitted in our
Yes, and wheelchair and all these things which the social welfare will provide as per the regulation. Yeah.
So that's here.
No, he has given that. He has given the photographs which he is going to provide. No, the wheelchair shall be provided to the or artificial limbs whichever shall be done on the basis of the direction of the doctor, whatever it is given, and which the state shall provide. I think that makes it more simpler.
have noted what are the requirements.
So that is why one of the specific question was put to the RIA. So it will be made on the basis of, because she, as per the commission's reports, her longevity will be till 50 years.
At least the-
50
right
years.
now,
So this needs to be done by the state. I'll dispose it of, CAB, I'll pass the order.
you're right to us.
So for permission.
Huh?
Because they need to enter today, right now coming to the.
At the request of the learned counsel for the petitioner, matters in adjourned to be listed after the publication. There was a fixed question, like.
Yes, it's pretty, the tighten of the whole money of the condition. But before you want to, I want to take the logic. To the order. It is, first order is by the fixed bank.
What is this? Why this case has been filed? You have filed, you have approached the bank earlier?
Yes,
What happened? For what?
that is the thing, whether I want to, on fixed bank 19,
Yes,
you know, all of the high school
6, 9,
19.
98. Or 90, what is that? Authorized withdrawal, unauthorized withdrawal of an amount from the SB account of the month standing with the state bank, the present.
Recoverable is the lauded.
Yet did no progress have been made in the result of this petition. So you want the progress in the investigation? That's all.
So. But not only that, but then.
Yes, what is the status of the investigation? That's okay.
Yeah.
What has happened to the investigation?
Report has been given to them. Report has been given to them.
Hmm.
So, or again for 21, order for the WC is sitting there, a report dated 31/21 from Caste has been received by the High Court, which is in the record, second point. The second point. And 31/3/21, the report of SP, you will not stay there. Some suspects were identified. They identified the suspect, not suspect, but due to assembly election, the OC was winning. So these cases, they were the idea. And what is our figure in that case?
Who is paying for the state bank? Yes, what is your stand?
One of these transactions were done through UPI. There are some apps which are integrated with the bank. We have nothing to do that. Suppose there is a Google Pay. The transaction, the Google Pay is the third party application. There will be transfer. So obviously, the election that they have placed. So just take it that the transaction, some payment has gone. The UPI, some payment have come to you. They also say that one phone call we have received from somebody that through mistake one payment has been done to the bank. We have nothing to do here. These are transactions with UPI.
In the fraud, but
No, fraud.
and tell me that today actually, whether I was 100, it was very interesting. Yes, sir. By our high court. Is a detail case.
You are referring to Justice Surana's judgment?
Yes, yes.
Justice Surana's judgment is on a different thing, where as regards the card which was issued, that card never reached the person concerned, and in the meantime, there has been a lot of things which are, and neither they have informed that the card was sent. This is a different thing from the mobile. But what about this mobile thing? What is to be done in that regard?
Yeah.
The fact, no, I think,
Yeah, in this case, but
Mr. Bogotuki, I think whatever they are saying, this was the superintendent of police is saying, needs to be brought on record by way of an affidavit. If this is affidavit is filed, then we can take care of what you are saying. Miss,
4 years already gone by.
huh?
4 years already gone.
No, understood. Miss S. Burwa, appearing on behalf of the Superintendent of Police Golaghat, have placed an updated instruction. I had placed an instruction dated 5/5/2021, issued by the Superintendent of Police Golaghat. It is further seen from a perusal of the state report that as on the date of the said instructions so placed, the case was pending, and it is not known what has happened thereafter. This court fixes the matter again on 9th of November 2023. The SP Superintendent of Police Golaghat is directed to file an affidavit stating the updated status of police case number, a PS, there are the Dergaon PS case number 786/2018. The said affidavit be filed by 7th of November 2023. The instructions so placed during the course of the hearing is returned as the same is incomplete. Let them file the affidavit, Mr. Bogotuki.
Yes.
Let them file the affidavit.
Yes.
Once they file the affidavit, then we can take it out, because this is another issue. This is Surana's case is where the card never reached the person. And as such, when the card did not reach him, so under such circumstances, any spending made with the card would have no consequences upon that person. Here is the case which is further relevant, because there is two other cases, which I may also mention. One matter is still pending in the division bench. That was a case by one of your colleagues, Mr. Pallab Bhomik, where also it is a case of a UPI transaction. I know, because that is the judgment which has been passed by Justice Sumansha.
Yeah.
And the matter was there. We have admitted when I was sitting with the Chief Justice, we have admitted. That is one. There is also one order which has been passed by me, which have also been upheld by the division bench. That is a case pertaining to Justice B.D. Agarwal, where some amount of money was taken from there. But the case therein is a bit different, taking into account that there was a direction. There is a particular, they have a policy. And in that policy, it is said that if till the amount is removed from the bank, you can make a complaint. And if you make a complaint, then they will hold it. There was an RTI information, they said that we were holding it till the complaint was made. And as such, they could not escape. So this is the reason why that judgment has been passed. But your case would be squarely covered with Justice Suman Shyam's order. This is a case of Pallabhumi, where that is also a case of UPI, where some shirt was purchased for 4,000 rupees and it ended up paying something around 1 lakh or something. Eh?
Sudan is case. Without Sudan.
That is a different, on the facts will be different. But this is a very important point, taking into account, because from the report it is apparent that his mobile got lost. If his mobile got lost and thereupon, and that mobile was used in by putting 3 post SIMs, or that particular SIM which was there were put in different 3 mobiles of different IME numbers. And on the basis thereof, he was getting all these SMSs. So the moment he's spending this amount, he used to get the SMS, and from there he's get the money back. So this is how it was being done. Then what would be the impact on the state bank? Can it be made an impact on the state bank because it is done through a third party? So this is their case.
Somebody has certainly purchased it, and they also have the password. Certainly the password is also shared.
See, the password can be very well changed if you have at a time when you are using the Google Pay or Paytm, whatever may be, lost password, then it comes back again to the SIM.
No, but loss of eligibility against the that's why it's a doesn't say one password comes to the user, one password comes to the registered mobile number. The both of them plug together and that is two passwords beneficial. So without one-way, so it is a.
But you have not mentioned that in your affidavit.
No, they have not mentioned matter, what has come up because their portion says that they want the investigation to.
No, you want the money back. Isn't it his prayer? That is his prayer. Yes, see the relief.
One proper investigation through somebody deposits the money will return it back. That is UPI third-party service providers are not a party there. So they will be the best.
You are not asking the money from him. No. That is what I also read. You want the money through him.
Through me. That is.
You are not asking the money from him.
That is all. Under this reminds that the person also.
That I remember. Yeah.
The
whole matter.
Not very pleased to issue notice. As to why a whole matter shall not be transferred to the federal following. And getting the coverage and return the money to the State Bank of Delaware. The tune of this so and so.
So what you are asking,
And
recover the money from the accused and pay it to the state bank, and so that you get the money.
Yes.
But you are not asking the money from him.
so these are the police investigation. That is
So that is why he's very happy.
We want to help it, and we also have to understand how things are happening because we.
But I think, don't you think that you should put it by way of an affidavit, that aspect as to how it can be changed, what you are saying? Because if that is there, then it would help this court in passing appropriate directions. Because this will have a lot of, this is every day's affair. Everybody is using Google Pay or Paytm. So this may happen to everybody.
Another on the responsibility, direction to the branch manager. FBI, Jargon branch, general manager. As they were so. To gathering all help with the relevant documents to CBI, whether money which have been forcibly withdrawn through UPI.
First of all, this matter has to be sent to CBI. You are asking this. And so, Mr. Bogotogri, what spelling you have put? Crime immediate investigation in your prayer, CBI.
From
The learned counsel appearing on behalf of the State Bank of India is also directed to file an additional affidavit. The State Bank of India is also directed to file an affidavit explaining as to how the UPI transactions work and how passwords can be changed. And as to whether passwords can be changed with the if the phone, if the mobile handset as well as the SIM card is misplaced. So then you explain it, then it becomes easy. Okay, next.
Number 6. What I've gathered from the authority is that there are 4 files regarding to there are 2 physical files and 2 e-office files. The 2 physical files have been sealed by the Vigilance Department with the review on an complaint being made by him. So it's difficult enough at this moment to produce those. But the e-office files, those entire documents are the next file. And also from the date when the authority, the jurisdiction of this also handed over to the landing office, almost everything, all the records are maintained.
What is this lumping coming into this sheet? This is another matter.
That departmental catering format.
That is what in platform number 1. Platform number 1 and platform number 2. Isn't that the case? It is in lumping.
Under Laming, till Kamekha, it's under Laming division, and that side of Kamekha station falls within the rear.
Where is that affidavit?
There are 2 e-office files.
Now tell me, how have you given it to somebody?
But the process for initiating the tender, those records are in the e-office file number 56365, and the process for fixing the reserve price is in the e-office file number 57409. All these documents start from page 369, my lord, and ends at 397K. 397N.
Yes.
The e-office file.
No, here is a case where he was running in platform number 1. You one fine morning thought that you shift him to 2. At the time when you have taken the decision to shift him to 2, prior to that you have already taken the decision to follow through the NIT. Isn't it? So that is why this court asks, how did you do so?
That is not the case. Initially, there was a discussion at the headquarters level. The GM and other top officials, they took a decision that there were 8 department catering calls. Between Kamekha and quantities. Decided that this stall should be settled by way of NIT. And in terms of the decision, the landing division was.
But his period was ongoing.
Yes. Yes.
Up to? So then why did you do that?
These are departmental catering stores, as I mentioned earlier. These are stores belonging to the railways. His appointment was not against a particular store. He was just engaged as a commission member. And railway has the right to rotate him to relocate his place of business. Everything is supplied by the railway in case of the commission members. He just earns a commission on the sale process, nothing more than that. And in the contract agreement itself, it is absolutely clear. He is as a commission member, and railway, in terms of clause 5 of the agreement, has the right to relocate his place of business, relocate the departmental store. By exercising that power.
But wouldn't his commission come down the moment he goes to some other one, number 2?
At this moment, it would be hypothetical, my lord.
No, you must be seeing out there because he's giving you more money.
Now he's a licensing man. He's a licensee, he's not a commission member. He has been settled by way of tender process. Everything, my lord, whatever he sells there is his property. Is his property. They will just be.
So the railway had taken the decision that this particular shop,
Eight stores, not, he is not a single of.
this particular store, we are going to license it out. The concept of commission vendor shall not be there in this store. Where is the decision?
Hello, I have to go back. People also take page.
So there has to be a policy decision, for changing it from commission dealer to this.
The process was initiated in the month of May 2021. I've stated that in my. Taking by 2021, there was a video conference meeting held by the GM with all principal head of departments and regional railway managers.
Where is it, paragraph?
Paragraph
Three. Yes, read it.
The department makes to state that the principal chief commercial manager in short PCCM and a failure handed over the administrative control of all departmental catering units available at Guwahati and Kamakha railway station to rounding region, except the extended management of accounting procedure and management of staff of departmental catering units by this letter dated 16/21. On receipt of the letter dated so and so, may be disbanded. The department further makes to state that the video conference meeting was held by GM general manager and included all principal heads of the departments and all regional managers were 18/2021, wherein it was decided to issue an IT in connection with the department stalls immediately. The same decision was communicated to the regional railway manager, rounding by the principal chief commercial manager and a meeting writing by the letter number so dated 21/7/2021. On receipt of the letter of principal chief commercial manager and a 21/7/21, rounding division on 21/7/21 itself. That is the very same, they initiated E of this file number so and so for issuance of NIT dated 9/8/2021 and ancillary correspondence with zonal headquarters was also done in the E of this computer number so and so. It is pertinent to mention here that since control over management of staff still remains with the zonal headquarters, termination of commission vendor service letter to the petitioner was issued by an office of the zonal headquarters on behalf of PCCM and railway on 28/7/2021 and accepted to its petition. It is further pertinent to mention here that the letter dated 28/7/2021 issued for termination was subsequently withdrawn by letter dated 29/7/2021. However, fixation of reserve prices other necessary approvals for calling tender dated 9/8/2021 was done in the office by number switch. Hello, what had happened was after the decision was taken to store NIT with regard to this call, his vendorship was terminated. Subsequently, it was the very next day. On realizing that there was some confusion with regard to who was exercising jurisdiction over the store mine, whether the headquarter or the zonal railway planning. Now, thereafter, the NIT was floated. Once the NIT was floated, he was agreed, my lord, he came before his honorable court, filing this petition. On that day, my lord, it was taken up on 6/9/2021. On that day, my lord, the written instruction which the railway provided to me, I had placed it before the honorable court. That written instruction is very important. Why, my lord, the decision to ask him to vacate the store was taken subsequently. That written instruction also has an explanation. When it comes to the
Eight.
On page 400, the relevant portion. People find page 400.
Yes.
Railways reply to raised by the petitioner are as follows. I think I've got it. On violation of agreement dated 19/2020 executed by and between the petitioner and then.
Page 404. Or there are railways reply on the issues raised by the petitioner. Okay. Then
On violation of agreement dated 9/3/2020, executed by and between the petitioner and NFA. Number 2, impute termination letter dated 28/7/2022 issued by restaurant number 4 arbitrarily terminating the petitioner from commercial vendor service. Railways reply. Clause 5 of the agreement of commercial vendor executed between Deputy Chief Commercial Manager ENC Catering Maligaon Guwahati and RJ Padmaraj on 9/2020 states that the administration reserves the right to introduce the rotational system of vending and the commercial vendor shall raise no objection if the duties place of work is changed by the administration and he shall perform his duties in the manner stipulated by the administration. Exercising the above clause, Railway Administration has decided to change the duties and place of work of Sri RJ Padmaraj commission vendor of South Indian Snack Bar at Guwahati railway station as the sale of a South Indian stall managed by him had drastically reduced in the year 2020 as compared to 2019. If the earnings of the same South Indian stall of Guwahati was not reviewed, it would have had a negative impact on achieving the summary earnings target set by the zonal railway. As such, London Division has invited an open tender for awarding each stall at PF number 1 between pillar number 24 and 25 for it.
How are you comparing 2019 with 2020?
That is there, but even prior to that,
No, you are not showing prior to that.
I do not have record with me right now.
How are you comparing 19 with 20? Because 20 was the COVID.
I'll come.
You have shut down all the truck, all the trains and everything was shut down. Railway stations were closed. People have been asked to put masks. How will they eat from South Indian dosa?
I'll come for your Now, the last paragraph is important. This change was not intimated to him. He will stop present railway earnings from the South Indian stall. The change of duty and place of work of the commission membership Padmaraj will be intimated only when successful bidder will be selected by the London Division in the transfer manner from the same open tender. As such, there is no violation of the agreement with the court. So this instruction was placed before the Honorable Court, and taking note of this final instruction, the Honorable Court was pleased not to pass the interim order in favor of the court. Thereafter, my being agreed, they approached the division with this matter. The division makes took note of everything and thereafter passed an order, my lord, which is also annexed in one of the affidavits which have filed in this matter, my lord. It's the affidavit which I have filed on 11th of May 2023, the first time. It said there was the liberty of the 180 and the
180.
7. Start from 180. Writ appeal has been filed that the writ appeal and petitioner against the order dated 6/9/2021 passed by the learned single number 4. Effectively, the interim relief sought by the writ petitioner has not been granted. The brief facts of the case are that the petitioner has license for running the stall catering service at the Guwahati railway station where he sells South Indian at the time. Appears that an agreement was executed between the railway and the authority on the writ appeal and petitioner for this purpose, which is subsisting until March 2025. Meanwhile, under the new tariff policy of Indian Railways, the petitioner has been given a notice dated 28/7/2020.
So the railway, the division bench didn't do anything.
Well, the last two paragraphs would be relevant.
What is there?
If there was any.
In view of the above statement by Mr. A. Dasgupta,
Mr. A. Dasgupta, Learned Standing Council, Railway has very clearly submitted that the railway is at a very advanced stage of finalizing the tender process and the technical piece of the tenderers have already been examined. He has also stated that the writ appeal is still running the stall catering service at the Guwahati railway station and will not be disturbed till the bids are finalized by the railway. In view of the above statement made by Mr. A. Dasgupta, Learned Standing this particular paragraph I'm harping upon here to impress upon your lordship that if at all there was a lacuna with regard to issuing a notice, my lord, that was cured or
Cured for what?
cured or my lord, that lacuna got cured by this observation of the Honorable Division Bench that in the event of finalization, you will be given a notice. And that notice, 2 notices were issued to me prior to asking him to vacate this one.
Notice for what?
Notice for my
We have
lord,
already taken the decision to remove him.
to remove him, yes, my lord.
He is only on that.
Initially, the decision was to terminate him.
See, not passing an order to or not interfering with the tender is a different aspect of the matter, because interfering with the tender would be if at a later stage he loses the case, then what will happen during the period? He will get a certain advantage by allowing him to run. His basic idea for challenging it is if he gets a stay, you have no other option but to allow him to run, which he wanted. The division bench, single bench and the division bench said no. Let them go ahead with it. If you win, what is going to happen is that the entire process will go and so and so.
And in the event, it's a finalization, given a notice, given due notice. Twice, my lord, and it's an admitted question.
That is a different thing. That notice and has, this is subsequent. But the question is whether you could have done so.
My lord,
That's the only question.
in my humble submission, if he was a licensee, he was given the.
No. It's not a question of licensee. It is a question of a departmental stores were there, stalls were there. Which were run by the department through the commission vendors. Now what their department have taken a decision that we are losing revenue, and as such, we are going to have a license, and then thereby we are going to meet the estimates which are being given by the Zonal Railways. That is the case. Now the question is, what is the parameter you have used? The parameter used in 2019, he had a good sale. 2020, it is not. Now, can you say that will be the justifiable reason for that?
And follow here in the case where he doesn't have my respectful submission to claim, my lord, that he has to be, my lord, allowed to operate a particular store,
So you are on to clause 3,
cross 5.
clause 5.
And it's not a case that he has been relocated for the first time. Even earlier, my lord, he was relocated on 3 or 4 occasions, and these facts are on record of the case, rather than gold regarding relocation of his store. He never objected to it. My lord.
So what is the details you have given that there is a loss? What was the sale figures in 2019?
And he said 59 lakhs according to him. My lord.
And what is the sale figures he is showing now
And
in 2021?
so far as, my lord, his sale figures, we are not concerned because he's the.
Why you are not concerned? Because you are getting the benefit. How much you are getting per year
22 lakhs.
from him? And how much you were making the profit in 2019?
Out of 59 lakhs, my lord, it would be hardly 16 or 20%, and out of that 12% he used to take. And basically, we are sustaining losses. Why so, my lord? My lord,
Because you have never mentioned that you were sustaining losses in 2019.
my lord,
These were the facts and figures which you should have brought in.
there were.
Yes, if there is a profit or some amount is being earned by the railways, definitely you may have a good policy decision. Yes, we want to earn more money, and thereby we are getting 22 lakhs from him. And how much you were getting at that point of time from him in 2019? How much did you pay?
After distribution, my lord, I have mentioned it.
At page?
Something that was.
118, my lord. After distribution. That is their certificate, man.
Yes.
This is to certify that Sri Parmar is the solution of South India's network, Guwahati, railway station of Guwahati. He gave a total sale of railway an amount of rupees 59 lakhs 11,502 and had earned a commission of 6,56,000 for the period January 2019 to December 2019. And rupees 16 lakh or mother had earned a commission of rupees 1,70,000 for a period of January 2020 to December 2020. Due to COVID-19. In 2020, the sale comes down because of our regular train services. We assure you to keep sale like previous years when the train services comes normal.
Who is this assistant catering inspector?
These are the person for, in all probability, who are managing the affairs of the store. There are 3 catering inspectors, my lord, whom we have to employ and we have to pay. And probably we have to pay a salary of around 80,000 per month to them. If we combine all these cost factors, my lord, this stores are running in losses. That's the thing.
But where is it? It is running losses. Now, are you saying that the railways are not providing you instructions to support the case of the railways? Huh? No, isn't that your case? Yes, you may have a decision, but can you base your decision on 2019-20 figures? Because 19 is different than 20 is bigger. Let us assume 19 is assume 19 and now. He is paying you 22 lakhs per year. Now, whether you were getting, how much were you getting in 2019?
2019, the total sale proceed was 59 lakhs. Out of that, the profit would be maximum 20%, not more than that. And out of that 20%, he takes out the 12% as commission. Not more than that. I can assure you. It will not be more than 20% profit.
Show me his appointment thing. It must be mentioned somewhere.
Yes. Yes. It's there in the affidavit.
Huh?
It's there, my lord, that-
No, his appointment as a commission clerk.
that agreement law should be fine at 812, my lord.
112. Yes.
Clause number 9 is regarding.
Clause number 9.
Page 22, the percentage of commission that you done in. Page 22.
What page 22? We are in 100 and you are saying page 22. We should go back.
Page 140.
Ah.
Well, the relevant clause regarding funding of profit is clause number 9.
9. The commission shall be payable to the commission vendor, shall be regulated by the rules, regulation, and order as may be issued from here. Shall not be entitled to any other remuneration except the commission for the sale of the articles done. The commission shall be paid through regular commission bills prepared monthly for the purpose. Okay, then it is not clear. You are saying 6%, 12%. What is it? Because let us assume this particular page which he has shown, page 118.
118.
118. He was getting how much? 6,56,000 on 59 lakhs. Then what is it?
I have just taken this question, madam. It says around 40% they are for the railway. It should be around 23 lakhs. Out of 50 lakhs.
How much commission you got? You filed an affidavit in 2019. You can't say this. And then on the basis of 2019-20, you are doing this. You couldn't have done that and throw him out.
2% of 59 lakhs would be about 7 lakhs 9,000.
No, madam, 40%.
So this commission would be around 12%. Commission of 6,56,000. And how much were you getting? If your basis is only, because your affidavit says something else. Your affidavit says that you have taken the decision on the basis that 2019 the sales were good, 2020 is bad. Now, if that is the reason, then it is bad. You couldn't have done that. That is it. Then only we can know. Yes, 2019. If it is that you are getting 10 lakhs, now you are getting 22 lakhs. Obviously, fair enough. But your affidavit is spoiling your case. I hope you understand. You have spoiled your own case. The person who was more clever to draft this affidavit in this manner.
The person who was taken the decision initially, he got transferred. Now new persons are coming, my lord. So
they don't know.
10 days.
What 10 days? From where?
And calculation.
Calculation. It these only days, how much were you getting in 2019, 20, 19 and 20, or even in 2018? When were you appointed? It will be there, na? As per this.
This agreement is from 20, my lord, but earlier also I was getting on this matter.
Since when?
Since my days of my father, my lord.
In the same stall?
Yes, sir. Same stall. Same stall, my father and my mother.
Hey, he says that you have been notational.
No, my lord, that is, I am clearing that. My lord, that original principal place was always there. They had put a extension that kept on rotating, my lord. But original place of business was always there in between the pillars, my lord, from my father's day. Now mother took up, and after mother, my lord, I am taking up, and from 2020 to 25, my agreement.
Sure. Like you do. The railways, pursuant to the orders passed by this court, have filed an additional affidavit on 14/9/2023. In the same affidavit, more particularly in paragraph number 3, it has been mentioned that where is that you mentioned?
360.
Huh?
360.
362. Now 1920. Where is it? I have mentioned that
118.
on receipt of the letter dated 16/6/2021 of the PCCM NF Railway, the divisional railway manager sent a letter dated 17/6/2021 to the PCCM NF Railway stating, amongst others, the departmental catering units at Guwahati and Kamakhya may be disbanded. Subsequent thereto, it has also been mentioned in the additional affidavit that the video conference meeting was held by the general manager NF Railway with principal head of the departments and all divisional railway managers on 18/5/2021. Wherein it was decided to issue a NIT in connection with the 8 departmental stalls immediately. The reason why the new departmental stalls, why the departmental stalls were converted to licensed units cannot be discerned from the said additional affidavit. However, from the enclosure to the said additional affidavit, it reveals that the railway administration had decided to change the duties and place of work of the petitioner, as the sale of the said vending unit of the petitioner managed by the vending unit managed by the petitioner had drastically reduced in the year 2020 as compared to 2019. At this stage, this court finds it relevant to take note of that from annexure Annexure 11 to the writ petition, the total sales of the railways from the vending unit managed by the petitioner for the period from January 2019 to December 2019 was rupees 59,11,582. And the petitioner earned a commission of rupees 6,56,575. However, for the period from January 2020 to December 2020, the same figure was rupees 16,02,321, and the commission earned by the petitioner was rupees 1,70,608. It was also mentioned in the state certificate issued by the Assistant Catering Inspector HQ, NF Railway, that the sales have gone down in the year 2020 because of non-regular train service on account of the COVID-19 in the year 2020. From the above, it is therefore seen that if the same figures of 2019 and 2020, and if seen that if the reason for changing the reason for tendering the departmental stocks, including the stall vending unit managed by the petitioner, is on the basis of the figures of 2019 and 2020. There has to be certain justification in the by placing on record materials by the railways as regards the difference in the earnings of the railways prior to during the period 2019 and pursuant to the tender being the license being issued to the respondent number 7. However, there is no materials to the effect, although the counsel for the respondent number 7 submits that they pay 22 lakhs and odd to the railways yearly.
22 lakhs,
22 lakhs 22,000 per year to the railways. Mr. B. Sharma, the learned counsel appearing on behalf of the railways, had submitted that he would like to file an affidavit bringing on record as regards the earnings of the petitioner of the railways prior to during the period when the petitioner was appointed in respect to the vending unit managed by the petitioner during the period from 2020. The agreement is from 2020, right? During the period of 2019, from January to 2019 to December 2019, and what is the rate? How much is the earnings of the railways pursuant to the license being pursuant to the departmental stores being converted to licensed stores. Departmental store and the vending unit being converted into unlicensed. List the matter again on today is how much? Today, Sundays. No? This is the matter on 5th of October.
It's already part.
Is it part?
No.
Taking into account that taking into account that the matter. This court, however, they finds it relevant to observe. Lists the matter on so and so into decision 511 for further consideration. 510 for further consideration. You were not there here.
No,
Then
next day, I had so many matters.
Fourth, my sixth.
court is not possible. Court is a Wednesday.
Or six.
6th is the Friday.
Then how I'm going, yeah.
3rd is Tuesday. Tuesday that will be opening. Then now it's too early for him to file an affidavit.
Then
On 10th for further consideration. I've said now for further consideration.
Okay.
At 2 o'clock, I will only take up urgent matters. Other matters are not. I have some other work. Yes, what is that? Yeah. 2 o'clock we'll hear. Seven after vacation? Okay, which year? This one? Is this that matter?
But regarding when they are supposed to produce the matter.
No, we'll take.
Fine.
8 has been adjourned. 16.
Not a single quality of has been I will carry this for I will carry 5 tomorrow or day after tomorrow. 4 years old.
We have fixed it on 410. Why the matter has been come today? Matter is fixed on 410. Huh? So 410 is when? Next week. Then it is already there. You see, the question is, on the last occasion, they have mentioned that they are in the final stages of this. So I have asked them to actively taking steps for the purpose of acquisition of the land in question, taking into account, let the matter be listed for update as regards the acquisition process. Then huh? It is already there on 4th. This is a land which have already been taken.
Yes, boss.
Your land has been taken. And how much is the land? 4 bighas,
4 bighas, 50 lakh, boss.
15 lakhs. Until late, no payment has been made. The instant interlocutory application has been filed for early disposal of the accompanying writ petition on the ground that the applicant, oblique the petitioner, is 74 years old. Taking into account the order passed on 7/8/2023, whereby the writ petition has been fixed on 4/10/2023 for update as regards the acquisition process. This court is not inclined to pass any orders in the said interlocutory application. Accordingly, the interlocutory application stands closed. It is made clear that the learned counsel appearing on behalf of the Water Resource Department shall ensure that the update as sought for by this court by the order dated 7/8/2023 is placed on 4/10/2023 without fail. Yes, item number 7.
Hello, 7 for you.
Yes, what have you got? So as per them, there is no document. Then, if this is the information, then on what basis did you give that license to him? Or what is the SC certificate? SC. No, therefore, this court specifically asks, how do you link patta number 25 with patta number 37? You couldn't link anything, and except the affidavit filed by the respondent number 7, there is nothing else. Where? This is what he has stated. The same thing, as per the Jamabandi report available at the office of the undersigned, there is no name as recorded as Haro Mohan Das or Haro Kabatsar in the scheduled land covered by PP number and DAG number 83. However, in the schedule of land covered by PP number 37, DAG number 82, there is a name which Haro Mohan Das, son of Manik Das, is seen to be recorded. As per the notary affidavit produced by Sri So-and-so, he is claiming to be the grandson of Haru Mohan Das or so and so, it is seen that Haru Mohan Das and Haru is the same. It is seen that Haru Mohan Das is saying, other than notary affidavit, we do not. So he says, and on the basis of that, you have done that.
This is the information.
And this was given when? No, madam, when was this affidavit filed? Only 2 days before. Then, so you don't have anything. Yes, you have for 7. Tell me. Filed on. When did you file? Yes, got it. Affidavit in opposition is. No, wait. Additional affidavit, no. This is an affidavit. Affidavit in. Yes, tell me. Huh? Yes.
Earlier, it takes the order for the inquiry, then deputy commissioner for the inquiry for conclusion, and the third commission on the basis of monthly report and other committees.
They don't have any other document. What is that Mandal report? Show me.
Monthly report is my lord. Look by report of the council.
What does he say?
Then on the next step.
Wait. On the last occasion, madam, you have placed some document. Where are those documents? Beginning of it. Yes.
Next day, Davras. Thank you. Davra has given the details. Those all documents are placed when inquiry has been conducted. All those documents.
No. Can the Gaubra say? What was the age of the Gaubra? How did he say anything about Har Mohan to Coimbatore? No. This Gaubra who was there, how did he give that certificate?
Because the hearing was taken place.
With whom?
Yes, all that this is all the thing has been again.
Now, how can there be a hearing in front of the Gaubra? I was saying the deputy commissioner was present in the Gaubra. Then, between whom? The inquiry is a farce now, as could be seen from the report of the circle officer. He says that except the notary certificate, there is nothing else.
Then will also kind of say, my, order, the order here, place 13. Everything is mentioned here.
Page 30 now.
Of my. From paragraph 1 to. What is the that has been Deputy Commissioner Bhavna submitted the report by friends to the the position will consider following the gas Processor called the statement that the gas name was Borough Proposal alias from he used to write as Borough Proposal as becomes testimony. He submitted a certificate to be.
Mr. Ahmed, I have looked into all these things. And therefore, your basis was this particular document, which is at Annexure 7. Now, therefore, this court had asked him how this name of Haramohan Koibutto had anything to do with Haramohan Das or whoever it is. Because this is in respect of Patta number 25. Now, see your application. What is your Patta number? What is your Patta number in your application?
25.
No,
What is that? It is
no, your application. What is the Patta number?
Annexure 7.
What is your application? In your application, what is your Patta number? Report of the caste certificate. What is Patta number? 26. Okay. Okay. And this is Miyadi. Annexure 7 is Miyadi. Okay.
But he put those documents related to the current. That my lord, whatever, he clearly stated, his father also found an affidavit. It is on record. He has also, right? Father also found an affidavit there. His father's name, original father's name is
No, whether these people say, because otherwise this court wouldn't have said, you have never taken the pain into 33 years for the purpose of getting the caste certificate. This therefore raises a presumption as to what is wrong, why you have not taken for your studies, why you have not taken for whatever job you wanted to take. These are all various benefits which have been given. Why you have not taken? All of a sudden, at the age of 33, now you remember your grandfather was Haramohan Koibutto.
At that point of they are not feeling that.
Huh?
At that point of time, they are not feeling. They are not availing this.
Why? They didn't know.
They don't,
They didn't know, or they didn't meet Mr. J. Ahmed.
Sometimes when some people want to identify that identity.
Huh?
Sometimes some people hide this identity. This is the some reason.
And now he wants. Why?
So since
No, why do you want the caste certificate now?
Since the some benefit is going provided to those people, so necessarily we apply. In also makes a paragraph close for a moment. Plus provide. The person is qualified as father submitted program in which they declare on that declare testimony. As their father, grandfather, it was also mentioned, it is said to be there, they are followed over to have some sort of, but next question, very important. For me, my. In order to further assess it, the genuineness of claims and counterclaims, a group of officers consisting members of SNC, i.e. Director of Liability, Director of Welfare Council, Director of Airfield Council, are to make export verification and submit report when suit is when suit. The committee make export verification on member and interacted with cross-section of people, including representatives of various social organizations of the community of Barbara district and rotate their views on the issue. After careful note of opinion, a view given by the various organizations and after examining relevant records, documents, the group of officers submitted their report on the issue. Finally, considering all aspects of the case and the basis of finding of the local inquiry and also considering the
No, where is the local inquiry report?
What about those reports, including all the we submitted all documents before the and
What documents did you submit?
yeah,
Yes.
Yes.
Show me your affidavit which you filed before them. Here it is there.
For those one document, I have total is 109.
Now this is dark number 32. 25.
And it also there.
This is a Borpeta Jila Anusochit Jati Parikhod. That is the petitioner. You have given a certificate that he belongs to the SC.
That has been denied by us because this is not minor. There is no record that he has.
This document is not there. And Ahom Anusit Jati Parikhod, who is it? What is the authority of Ahom Anusuchit Jati Parikhod?
There is a but one some this organization was headed to come under type with the SC minor. There are some recommendation which are one carried ever down. There are everywhere. And then minor.
No, what is the authority? You are for Borpeta. You are for Borpeta Jila Anusuchit Jati Parikhod. What is the authority? You are registered under a registration act. And that is for Borpeta. And does this access Ahom Anusuchit Jati Parikhod has any authority over you?
Mother, there, according to the mother, our service to mother, SC minor, general service, there are 3 minor. There must have been authorized to recognize
Who?
by the honor of the
Which one? By the Borpeta Jila Anusuchit Jati Parikhod or the Ahom Anusuchit Jati Parikhod?
minor, possibly minor, or some honor of the not by the. In case of ST minor, by the.
Because Ahom Anusuchit Jati Parikhod had given a certificate to the father.
They cannot issue that. Only they can apply the deputy prisoner on this basis they may issue.
They have issued a certificate. So this is to certify that Dhoniram Talukdar, wife of so and so.
There has been no problem report matter in that.
Why haven't you not brought on record this?
All those documents I sent to the authority at the time of hearing.
So you had this all this time. Why haven't you brought it?
That's one thing my lord, and another thing, my lord. The original certificate issued by the organization. Then it has been counter signed.
Huh?
It has been letter counter signed by
Which one?
the certificate. Because the earlier committee has issued the certificate. Now present committee now they denied it. It can renewable my lord. Earlier secretary issued certificate. Now present secretary say it is wrong. It cannot be taken into consideration by lord. One of it is issued. Next time they say it is wrong.
Yes, my lord. The students have written also.
They counter sign it.
Now, in 2008, Annexure L is a দরখাস্তকারী নাম প্রসেনজিৎ তালুকদার, বাপেকর নাম মনিরাম তালুকদার, মাকর নাম দিতি তালুকদার, দরখাস্তকারী ঠাই ঠিকানা বড়া পাড়া নগাঁও, দরখাস্তকারী পূর্ব আইন ধারা 50 বছর দাগ নম্বর 26 নম্বর পট্টা। Who is Dhirendranath Das? Dinesh Das. Inquiry. Inquiry report, however, finding in the instance is evident from the documents pertaining to land records and also the family tree that the great grandfather and grandfather of Chandrakanta Pathak used. What are these documents? That is example. Jagadish Talukdar.
Except nobody use the category that Baraku.
Yes, what is your name? Prohanjit Talukdar? Huh? And who is Jagadish Talukdar? Is your son? Is your brother? So you are a district unit of all Assam, Anusit Jati Parishad, meaning thereby all Assam is the parent. But there is some certificate being given to the father.
But not by the secretary. I have seen one by secretary. And the woman.
By the
Secretary. Yes, not certificate, but it was this certificate by the secretary. Yes,
given by the president.
And exactly page 7 of my relative.
No, this is Ahom. All no, is this the name is different? Because you are saying from all Assam Anusit Jati Parishad. This certificate is given by Ahom Anusit Jati Parishad. Ekon Dijoks. The Sorony can have a look out there.
Some Anusati Jati Parishad.
And when your father had this, then why you are not claiming all this while? That document which I have given it to you.
If we go there, it might not be registered as a contractor, we never know. Because contractor SC are getting benefit, some kind of benefit in tendering also.
Huh?
And college also he never told it. Yes. And this is why this certificate I did, we had the official seal of the official mother. Here either SDC or FPO or this is required, my lord. If it is so, my lord. Because.
No, because you say in your affidavit, in your petition at paragraph number 1, that you are a unit of all Assam Anusuchit Jati Porikar.
My, exactly.
Now that certificate is given by Assam Jati.
That is a difference.
That is what I am saying. This is by Assam Jati. And that is why the petitioner, because this is a very important document, why the petitioner has, response number 7 has not brought on record this document.
My lord.
And see the earlier page. The earlier, yes, this is the certificate issued by you to him. Now, why these two certificates are not being brought on record? Yes,
This certificate we are denying.
now understood, but why he is not brought on record?
Fortunately, my lord, because there is no record of this.
Last time it was those bundle of papers.
You have brought on record some land document of 1928. You have, why these are the vital documents you have not brought on record?
We cannot think about this.
Which are cleansing evidence. There's something wrong there.
Other decision for the committee of the. We got madam.
People understand what this is, by the way. Yes, I know it when it should better something in the room.
Which one?
That's the one that is
Yes.
fine. Because should better something in the room.
Then
All those different pivot organizations and they would get. A lot of our villagers were also heard. I also found that there is a census report, my lord, last page. Census report, my lord, last page of that document.
But with RTI in my census report, they are saying that nothing more. You can even in the.
But I also can say last page.
give it to him.
That's my lord. I have not.
It can be mentioned in the order also.
That's
I-
why
Now, Mr. Soronia, why are you fighting tooth and nail against his certificate?
No, madam. Because of that, my lord, immediately without any family background, any family member, he got the certificate politically, he became a chairman of the sub-division board of Kolkata.
Huh?
It's the one. Sub-division, chairman of the sub-division SC board of Kolkata, man. Board of Kolkata. So he is used to all financial benefits to the SC people. And he is the person who can issue certificate to the SC people. If who is not belong to SC, he is using all his power and position by law, and he is issuing the certificate to his villager, other villager. He is the first person who took the certificate.
And is he still functioning like
No,
that?
the position. But after my calendar, it government has directed the government department not to issue certificate. In inquiry is from and not to distribute any kind of beneficiary scheme to the beneficiaries. Thereafter, only in case of beneficiary part, because our people will be prepared. That's why we only stick to this certificate. Now, only integrated commission. So that there is one minor, become minor. For sure. The rest there are regarding certificate.
My lord, this census report, the order in paragraph 2 is been mentioned. Paragraph 2, my lord. That was in the paragraph submitted for the.
There are two of where?
Of Imbu order, this
Of your?
my evidence. Regarding the census report.
Page 13.
Paragraph.
Hmm.
The person that was submitted for the population census report, which is better. It is shown that out of 831 population of Bara village, 305 population are scheduled caste. The population census report shows that there are sizable numbers of caste population in Bara village, and therefore, consensus based better population would not be stabilized. Rather, this report provides inputs to stabilize the tendency of the person who follows the caste population. They are able to make villagers all of this with the question of head. That is to be because to be approved. But large number of.
No, no,
people-
no, your basis on which you were given an appointment or given the certificate is on the basis of your link with Harmohan Horokobot.
Yes.
How have you linked it? Till now, I have not been satisfied with your linking.
But because of that land.
That land has nothing to do.
After
Because
that-
the land which is there of Dag number 37, which they have produced on the last occasion, says about Har Mohan Das. No quarrel.
Yes.
Har Mohan Das is there. But how can you say that Har Mohan Koibotto is the Har Mohan Das? Haro Koibotto, not Har Mohan. Haro Koibotto is Har Mohan Das.
Because my lord, they use that land.
How do you know?
Because they stated, by they're filing affidavit.
Your affidavit has no value.
My lord.
You will do anything.
But-
Because this court is not only going to say all these things, but also direct investigation to be carried out as regards the falsification of an affidavit if it is done so. Because this is an affidavit which is being given falsely to before an authority. And as such, if it is a false affidavit, action will be taken against you. Because this is serious. How do you link both? Show me something. As of now, the circle officer has and the deputy commissioner categorically now says that except that notary, we have nothing. They have not been able to link.
Then my lord, in my petition, my lord, I read the document where I applied RTI, but then Bada village road SCL law. In 11, my lord, there from yes, my best procurement. I got in the on the bit of RTI,
Yes.
best 32 and I start.
No SC.
My no, it's the Bada village, this is the deputy director interview certificate.
On 2011.
My
And he says that there are a lot.
another thing, my lord, I have when there is notarial conduct, I submitted document, my lord, but I have not connected.
Now, interestingly, here, Bora village at Borpeta, the name of the village is Bora. Total household is 175. Total population is 831. Total scheduled caste population 325. Total scheduled caste male 158. And here the population is even. It seems that one fine morning after 2011, there has been huge lot of people who have gone inside.
As this is a national register of citizens matter. Here is a prolonged line matter. If any caste community you have to mention, nothing matter, no SC matter, in SC column matter. 90 picture of the matter.
But this is of 2011.
I have not marked any. When the citizen put it before that time. I have not taken it for granted. There can be easier contact or never use the matter. What is also matter, only to become a factor.
No, Mr. Ahmed, this court is not going to consider any of these documents as you have not brought on record.
But my lord, those facts are all of this is a question of fact.
No, if the facts on the basis of which they have done it, saying that they have a connection with this on the basis of land records, and that fact happens to be not proved, or they could not explain to this, then the entire edifice of your certificate is gone. Unless you show that Horomohan Horokobotto is Horomohan Das.
Apart from that, that's.
That is the only thing.
And apart from that land document, the large number of users were examined by the committee. Large number of people in ground.
Where is the committee's report?
It is mentioned in the order, but it is not in my hand. It
The
is
state
mentioned in
have
the-
also not produced.
It is mentioned in the order, clearly mentioned that committee has inspected the village. It has all large number of people, Gabras people also call for, Mandal people also. So. it's a thing of-
The government have written nothing.
Why the government is silent on that?
By the order, it will be mentioned about the injury.
No.
Here the government has said in their affidavit mainly on this, Deputy Secretary Welfare, so and so, that with regard to the money issued in the money, our precautionary measures, so and so, directed in so and so, the SLC. Was duly constituted in accordance with law and apparently
They are a bigger segment.
Yeah.
Explain for my end.
Madam, you could, who is appearing for the Revenue Department? Welfare of plain tribe and backward classes, who is appearing?
Now my lord recently stands by the different department.
Who is appearing?
And Central Department.
Who is appearing? Are you appearing for it? Huh? You are not.
The iron dust. My lord, of the iron dust. On the above.
This code, by an order dated 19/9/2023, had observed that the instructions which were placed on that date was not clear as to how patta number 25 became patta number 37. The government, the Deputy Commissioner, Borpeta, was also asked to clarify as to how in patta number 37, the petitioner's grandfather has been mentioned as Haramohan Das, which however is different from the person whose name appears in the patta number 25, that is Haro Koibuttu. Today, Mrs. Udas, appearing on behalf of the additional senior government advocate, have placed before this court certain instructions issued by the additional Deputy Commissioner Borpeta on 22/9/2023. A perusal of the said instructions reveals that the name of Horokoibuttu is seen in Kepi Patta number 25 in the Jamabandi copy, bracket 1923-2028. But the Circle Officer Borpeta, Revenue Circle, by letter dated BRC-49/2022/265, dated 22/9/2023, reported that as per the Jamabandi report available in the office of the Circle Officer Borpeta, there is no name is recorded as Horomohan Das or Horo Koibuttur in the scheduled land covered by the PP number 25 and DAG number 83 of village Bora, Mozab, Nogao. However, in the schedule of land covered by PP number 37 and DAG number 82 of village Bora, Mozab, Nogao, there is the name of Horo Mohan Das, son of Manik Das. It was further mentioned that on 22/9/2023, the petitioner had submitted another affidavit claiming that he is the grandson of late Hor Mohan Das / Horo Koibuttu. And both the persons are one and the same person. It was further mentioned in the said instructions that other than the notary affidavit, there is no other evidence which connects Horo Koibuttu with Horo Mohan Das. The said instructions are kept on record and marked with the letter X. Mr. J. Ahmed, the learned counsel appearing on behalf of the respondent number 7, during the course of the hearing had produced certain documents, which however is not part of the records. Under such circumstances, the question of taking into account such documents would not be proper. This court, however, finds it relevant to take note of the affidavit in opposition filed by the respondent number 1, who, through the Deputy Secretary to the Government of Assam Welfare of Plain Tribes and Backward Classes Department, in the said affidavit, it has been mentioned that there is a speaking order was passed by the SLSC, that is the State Level Scrutiny Committee, dated 16/8/2013. On the basis of the documents of the respondent number 7, as well as on consideration of the spot verification report submitted by the members of the SLLC, comprising of the Director WPT and BC Department, Assam, the Director of Welfare of SC Assam, and the Director AIRRT and SC Assam. The said order, however, is not a part of the instant records. This court, taking into account that the said report is one of the basis on which the impugned order dated 14. Oh, that order has no relevance.
This is subsequent to that matter.
Ah.
It This is 1400.
No, first. Trying to keep,
So taking into account, let us say.
they're taking into account. The said statements made in the affidavit filed by the respondent number 1 gives an opportunity to the respondent number 1 to produce the said report, said order dated 16/8/2023 on the next date. 2013 on the next date. It is made clear if the said order is not produced. No, first. Next. This court further expresses its displeasure Madam, you are not appearing for whom? You are appearing for whom? You are appearing for the Deputy Commissioner. No, you are the Deputy Commissioner. This court expresses its displeasure as the respondent numbers 1, 2, and 3 have chosen not to appear through their counsels, although it has been informed that they have standing counsels. Under such circumstances, this court fixes the matter again on Labit after vacation on 9th of November 2023. A copy of the order be sent to the Commissioner and Secretary to the Government of Assam, Welfare of Plain Tribes and Backward Class Department, semicolon, the Director, Welfare of Plain Tribes and Backward Classes, Assam, and the Director, Welfare of Scheduled Caste, Assam, who are the respondent numbers 1, 2, and 3. So that on the next date, so fixed, the report, the order dated 16/8/2013 is placed before this court. The respondent number 3, 1, 2, and 3 are further directed to either appear in person before this court on the next date fixed or through a counsel. What record? No records. Not concerned with any of these. Any more urgent matters?